My lord, may I be permitted to my lord, permitted to mention some matters, my lord. On 21st of March, your lordship was pleased to dispose of the matter. In this matter, all these matters are identical and same order may be passed, my lord. If your lordship, my lord, kindly upgrade this is for upgradation.
All right, take it.
Your lordship's order is I have annexed and my lord's notice also. Read to them.
This is pension matter, my lord. Since long, my lord, the petitioner is not getting paid.
My lord, new sanction plan.
What new sanction plan?
My
What is
lord, I applied for new sanction plan. But that was pending, my lord, before the Bonga municipality. My building is dilapidated condition. I want to construct, but without the sanction plan. And I applied for sanction plan, but they had, my lord, kept mum, my lord, for long 6 months, my lord.
It will come up.
My lord.
It will come up in due course. What is the urgency?
Item number, my lord, 2393, my lord, monthly list.
What is the urgency in this?
Urgently, I want to, my lord, construct building before, my lord, rainy season, my lord. My lord, in the month of June, my lord, 2 months at least required, my lord, for building, my lord.
All right, take it.
My lord, may I mention one? My lord, may I?
May be permitted to mention, my lord, the petitioner has become a stroke and paralyzed, my lord, and the petitioner was dismissed from service. My lord,
When was he dismissed from service?
when, my lord,
When was he dismissed from
the-
service?
2 years before, my lord.
So you can wait for 2 years, wait for
My lord,
2
My lord.
my lord, he is a paralyzed, my lord. He want to get a fate of a case, my lord. He can die any moment, my lord. So that give me priority to hear out.
Sir, I'll hear this matter. This is dismissal from service.
Yes, my lord.
Dismissal from service, right?
Yes.
Did you go to the Central Administrative Tribunal?
No, no.
No, no, no.
Why?
My
It's a
municipality matter.
For municipality matter.
Yes.
My lord, may I mention under extreme urgency, my lord, the local club has constructed encroaching my boundary wall public toilet without sanction plan. My lord, I cannot survive in that place. My lord, the public toilet is creating a menace. They cannot survive in that situation. The municipality is not taking any step.
Why
My lord,
can't they survive?
the offensive smell. My lord, the public toilet has been constructed, encroaching my boundary wall.
When was the toilet constructed?
My lord, in the year 2024. My lord, I filed in 24.
Take.
My lord, one restoration
Go on,
application. My lord, another is restoration.
My lord, I'm praying for upgradation only.
No upgradation.
My lord, the restoration application.
My lord, this is the taxation matter. My lord,
Go to the municipal
yes,
taxation.
I have approached them. They are not, my lord, kindly. They are not taking my representation. They are saying that you have already gone to the High Court. With this audacity, my lord, that you have already gone to the High Court, now get an order from the High Court and pray before us. Whatever is there, the High Court gives, you go.
You withdraw one of the petitions.
My lord, if I withdraw, my lord, kindly appreciate that their attitude as well. They have the audacity to say, without taking my representation, that you approach the High Court and get an order done. Because you have approached the High Court earlier.
See, sir, all these statements doesn't impress me at all.
I may not be able to prove my statements, but
Please
this
don't
is
impress
what
me
I'm,
at all.
my lord, this is what is the submission from the bar. Because I have made the representation on behalf of my client. My client went and,
I heard your submission.
my lord, kindly upgrades the matter. Whatever, my lord, the fate of the matter is, at least give me a liberty to
Why
approach.
should I upgrade the matter?
My lord, gives me a liberty. They are not taking my application. That is even pleaded in my writ petition.
You have filed with the pre-deposit?
My lord, there is no requirement. I have come under the writ jurisdiction, my lord.
I am asking not here, before the municipal valuation tribunal. Have you made the pre-deposit?
My lord, they are not taking my application.
You made the pre-deposit, sir.
I am willing to have made a representation in this regard. They are not accepting.
How can the registrar not accept?
Yes,
You write a
yes.
letter. Wait a minute.
The only thing
You
is,
send
I
it-
am a tenant. I am a tenant. I am not the recorded owner of the
Wait.
property.
No need.
My lord,
Lordship, may I be permitted
Wait.
to mention, Your
Nothing
Lordship, with regard to item number? Lordship, may I be
Restoration application. No, it was.
Restoration.
Lordship, may I be permitted to mention with
Wait
regard?
a minute. I'm hearing. Am I going somewhere? Have patience.
My lord, may I be permitted to mention one restoration application?
Restoration.
May I be permitted to mention with regard to item number 2491 of Your Lordship's today's list, Your Lordship. Lordship, after filing of the writ petition, Your Lordship, I was praying that a building has come up in the earlier writ petition. I've already preferred an earlier writ petition, which was accordingly disposed of, wherein the municipality has submitted a report that the building has come up without a sanction plan, and specific hearing was required to be given to pass order of demolition. Lordship, nothing was done despite the writ petition was disposed of. The entire construction took place and it is just adjacent to my building, touching the wall of my building. Lordship, after filing of the present writ petition, which is now appearing as 2491 item number, Lordship, the municipality has then issued a demolition notice on 22nd of March, Your Lordship. Lordship, let this demolition be carried on, Your Lordship. Lordship may kindly upgrade the matter.
Not at
My lord,
all.
I beg to
Lordship-
mention a matter.
Not at all, madam.
I beg to,
Nothing, no urgency. Absolutely no urgency.
I beg,
Lordship, the
Demolition notice has been issued. They will take action in accordance
Lordship,
with law.
Lordship, the
I'm sorry,
action has
madam.
not been taken till
Sorry.
date.
No
Lordship,
urgency.
Lordship, may
No urgency, madam. Sorry.
Lordship,
Next.
any date, Lordship, any
No
date,
urgency. No
Lordship,
urgency.
and with regard to,
Madam, no urgency.
and Lordship, also with regard to item number 71, Lordship, kindly hears me, Lordship. Item number 71, Your Lordship, I have filed it in the month of September. Lordship, herein I am running a management college, Your Lordship. I have prayed for repairing of the structure, Your Lordship, before the Bidhannagar municipality, Your Lordship. There already the portions of the building has already fell on the one of the staffs and also on the students, Your Lordship. Lordship, despite an order being passed by the municipality, the landlord as on date has not taken any steps for repair, Your Lordship. Lordship may kindly takes up item number 71, any date, subject to Your Lordship's
Item
convenience.
71 will come in due course.
Lordship, grateful to Your Lordship.
Without keeping a single inch, my lord, from my plot, my lord. I have
Construction, illegal construction.
Illegal construction, my lord.
All right. It will come in due course.
my lord, may I,
No problem. It will come up.
my lord, I
We'll
beg
get
to
it.
mention a matter, my lord.
Next.
There is no
Just
light-
a minute.
but there is no light and air in my home, my lord.
It- File a civil suit. Get a stay injunction.
I beg to mention a matter, my lord.
Yes.
Item number 1485, my lord.
Yes.
Gratuity matter, my lord, petition returned from 2018, my lord. My lord, till date, my lord, they have not received.
Gratuity.
Yes,
My lord, I beg to mention a matter, my lord. Beg to mention a matter,
Just a minute, sir.
my lord.
Yes.
About a month back, an order was passed that this matter would come returnable. My lord, the urgency is that we have crossed that threshold of 1 month. Though it has been already heard. My lord, the matter is that, my lord, I was making a construction on my land which was purchased in 2012. There was a work stop notice issued by the KMC. Now, the reason behind that is that they're saying that the part of the land is vested. As such, my lord, the BLRO was also made a party. A special officer was also appointed in the matter, and the surveyor was, and the BLRO was also directed to survey. That exercise is completed, my lord. Only the matter.
No urgency.
No, my lord, it was returnable, my lord, within a month.
All right, it will come in due course.
My lord, kindly includes in the list, my lord. It's
It will
not in
come
the
in due
list, my lord.
course. It will
It's
come in
not
due-
in the list, my lord.
It will come in due course. Wait. Restoration. give.
Lord, my part construction is,
It's all right. Disputed. Yes.
By signing a writ application. My lord, and now my lord, authorities are going to issue my lord work order, my lord. Right? Very urgent, my lord. If the work order is issued, my lord, that will be in fact, my lord. Item number,
Sorry? Yes. Sir, wait. These are not important. Yes.
I permitted to mention a matter, my lord.
My lord,
Wait, sir, wait. These are not
It is
that important.
demolition order is staring at face of me, my lord.
Demolition?
Yes, yes.
Not at all.
No, demolition already in progress.
Sir.
Demolition is already on progress. Already fifth floor has been demolished. Only thing is that more 2 floors has to be demolished. May I keep it any day, my lord? May dismiss my order.
Not at all. Yes. Yes, tell me.
My building only, ma'am. My building only.
Your building is getting
Yes,
demolished?
yes. That is why. I keep it on any day, my lord.
Yes. Pension, give it.
Open that.
Matter
Yes, madam.
for inclusion in
Done.
the list.
No inclusion in the list.
May I
Yes.
permit to mention a matter for pension matter, my lord.
Pension, give it.
My lord, may I mention another matter for upgradation, my lord? The unauthorized construction has been constructed in
Yes.
my property, my lord, by some third party.
Who did I see somewhere? I saw a familiar face.
My lord,
May I kindly be permitted to mention for inclusion of one
No
new
inclusion.
motion, my lord.
No inclusion, right?
Very urgent, my lord. Very
Yes.
urgent, my lord.
What is the urgency, sir?
Application for stay, my lord, of demolition proceeding, my lord. On 26th of March, they have served me a notice, my lord, to vacate the property and the tenure was expiring on day after tomorrow, my lord. Let it be, my lord, matter be fixed, my lord.
They must have followed the due process of law. What is the urgency in this?
My lord,
It's unauthorized construction?
They will
Illegal, do you have a sanction plan?
Yes, my lord, everything is there, my lord. I
Take it.
purchased.
It may be permitted to.
Lordship.
Well, might have your lordship indulgence to answer this matter. Well, a client is dancing upon my head, for which, my lord, your lordship kindly accept.
Sir, you mentioned after 1 week.
Yes,
Abhi, let me clear my board.
After a week. Then I'll mention after a week. Let authority.
mention a matter.
Yes,
Item number 178.
yes.
It is a matter of urgency, my lord. The petitioner is a housewife and has got 2 children. And the municipality is illegally taking up her property and stating that the property belongs to municipality, whereas the petitioner has.
Disputed question of fact. I'm not getting into it. Wait for your time.
Let me.
Kindly,
No, nothing. File a civil suit, disputed question of fact. Who's the owner? Municipality owner, you are owner. Go to the civil court. Yes,
Lordship, may I kindly to mention restoration application?
restoration given.
With regard to my lord,
No upgradation.
my lord, a matter, my lord, relates to unauthorized construction beside my
Upgradation, I'm
property,
not doing it. Right.
encroaching my property, my sewerage and my water supply has been affected by the unauthorized construction.
When you permit to mention,
How many mentioning you have?
mentioning.
Yes.
Unauthorized construction, my lord, my property, someone is constructing in my property, it's an unauthorized construction. Grateful, lordship.
My lord, for inclusion, my property is illegal construction is going on
Very good.
without sanction plan for inclusion.
No.
in illegal unauthorized construction, they have they made by private one.
Illegal unauthorized construction, are you doing? It's getting demolished. What is it? What is the matter, sir?
No.
What is the matter? What is the matter?
No, I think no.
If you don't know, don't mention it. Yes,
May I permit to mention item number 1745,
yes.
2474. Both are the PF and gratuity matter, my lord. The petitioners are depriving, getting deprived.
Give it. Yes.
Deprived.
Lordship, item number 2262 for upgradation, lordship.
No upgradation, madam. Sorry. Yes.
Lordship, it's
I am petitioner in person in
Very good.
W 518.
Yes.
The matter has been pending in the court
Very good.
cycle for last 10 months.
All right.
The
It can
respondents
remain pending for some more time.
are not listening to the 4 judicial orders,
All right.
including Justice Bakshi's order.
No upgradation.
Item number 422, pension matter, lordship.
Pension, give it.
Your lordship, they have already constructed.
Sir, wait.
Madam,
Let it construct. Anything which is unauthorized, illegal, will be taken to due course. It will get demolished. No urgency.
Your lordship,
Yes, any other mentioning? No, sir.
Yes.
Sorry, no, sir, no. Nothing.
10 months and 4 court.
Sir, don't. Nothing, no urgency. Yes.
My lord, there was some deviation, my lord. The order,
Deviation.
there was deviation, my lord.
Good.
G+1 sanction was granted, my lord.
All
I
right.
have.
Sir, wait.
Sanction
Let it construct. Anything which is unauthorized,
was
illegal,
demolished.
will
Now
be
the
taken
first
to due
one-
course. It will get demolished.
Demolish
No
the sanction
urgency.
area, my lord.
Yes, any other mentioning? No, sir.
My lord,
Sir, no.
my lord,
Nothing.
may I to permit to mention
Sir, don't make.
one of the combined monthly list
Yes.
mentioning for upgradation.
No upgradation. Yes.
लास्ट वीक मैंने मेंशन
Yes,
किया
Malad, good.
जस्टिस अनिरुद्ध मुझे ऑब्जर्वेशन है मेरा वाइफ बहुत बीमार है
हाँ दीजिए.
My lord, the entrance to my shop room has been barricaded by the municipal authority. The ingress and egress has been restricted. I'd already.
My lord,
unauthorized
Yes,
construction.
Mr. Chakravarti.
Sir, don't make.
one of the seeking leave of this court to move this matter on an urgent basis, my lord.
What is the urgency?
A demolition order has been passed.
Give it,
back
give
in
it.
2012.
Give it.
And
Yes.
may it be kept tomorrow, my lord.
Demand.
Demolition has been
My lord, the entrance to my shop room has been
Item
barricaded
number
by the
459,
municipal authority.
unauthorized
The ingress
construction
and
is
egress
going
has
on
been
my
restricted.
land.
Going
I'd
on.
already-
Let it go on. Let the unauthorized construction be
Yes,
done.
Mr. Chakravarti.
Let the buildings come up. We'll get it demolished, madam. Don't worry about unauthorized construction. Yes.
Move this matter on an urgent basis.
No. Nothing going to. Yes.
Be allowed to mention that my writ petition was heard. A detailed direction was given in Kolkata Municipal Corporation, but when the order came out,
Sir,
it was there dismissed. I think.
whose order? My
Yes,
order?
Yes, confirmed.
Take it.
And I
Keep
think
it
there was
for,
some, typographical mistake somewhere.
All right. We'll see that.
Lordship, may I be permitted to
Ask
mention
him
one?
just ask him what is the mistake.
Lordship,
Yes.
Lordship, may I
Yes,
be
yes,
permitted to
yes.
mention, Lordship, I'm mentioning it for upgradation, Lordship, due to the
No
unauthorized.
upgradation, sorry,
Lordship,
sir.
due to
Not
the-
at all, not at all. Yes.
I'm mentioning a matter, the matter relates to the mutation of a.
No mutation, no urgency. Yes.
Mention the matter.
Yes, fast.
I'm sorry, sir.
If the mentioning will go on for half an hour, when will I hear the matters? Tell me fast, madam.
it is about demolition order, which has been made again.
Give the file.
My lord, I'm mentioning for upgradation.
No upgradation.
For withdrawal.
Sorry, withdrawal. Give it.
My lord, may I permitted to
Yes.
mention one matter relating to illegal allotment of shop room, my lord.
Nothing now.
May I be
Yes.
permitted to mention one matter? My lord, the building is been constructed. as-
Very good. Let the construction come up. We'll get it
My
demolished.
lord,
Don't
my
worry.
construction.
Let the construction come up,
Name and
sir.
agents of the corporation
No
is
problem.
constructing my corporation.
Construction, no problem.
About the demolition order.
Demolition order. Your building is getting demolished.
Yes, sir.
Give it.
Unauthorized construction, Lordship, for
Unauthorized construction, let it come up. Let it come up.
Lordship, I'm praying for only,
4 floors. The builder will pay for it. No
I'm
urgency.
praying for inclusion in this matter, Lordship. This is a new motion application, Lordship.
Promotion, not now.
Lordship, there is the urgency,
Not,
Lordship.
not now. See, I have call out the list. So good to see all the faces, Mr. Gupta, Mr. Khatri.
My lord, our honored guest was willing to see a lordship's courtroom. So,
No, it's so good to see all. Ajinder is here, Mr. Mishra is here, Mr. Akhtar is here, and everybody is here. So good to see all of you.
They wanted to see a lordship's courtroom.
It's good to see
Lordship.
all familiar faces.
Yes.
You all are leaving today, Mr. Gupta?
Would have requested you to invite us.
Absolutely. Absolutely. You're leaving today only. Nobody's here in the evening.
Sir, it is a working, but
Working.
next time we'll come, we'll.
Absolutely. Please be my guest.
All the best.
Thank you.
Already our guest.
Be my guest next time.
Yes.
Thank you.
Lord.
You have a safe flight. Thank you so much.
Lordship, my lord, may I have a lordship's kind leave to mention, my lord, one matter, my lord, I'm in virtual mode, my lord. This is item 2489, my lord.
What is the urgency, sir?
Lordship.
I've
My-
called out the main list. No mentioning now. Call the
Lordship,
list.
kindly, my lord.
No mentioning now. Sorry. No mentioning. Call out the list. क्या है ये? अच्छा क्या करना सीन हाँ हाँ
সপ্তাহের মধ্যে পেমেন্ট করবো
तीन ना
আপনি আছেন আমার কোনো চিন্তা নেই আপনি আসার পর সব আমরা সেটেল হবে
डेट क्या सर
অনেক চেষ্টা করছি আপনি আসার পর আপনি আসার আগে আপনি অন ডাইভার্ট করে আমরা আপনি আসার পর হইতে আপনি ভালো করে লক্ষ্য করবেন দেখবেন আমি আপনি আসার পর এটা আপনার মধ্যে কোঅপারেট চার্জ আমি দেখি আপনি এসেছেন পর সবটা ধরে আপনার কথা কমপ্লিকেশন আপনার কথা অর্ডারের মধ্যে বিশ্বাস করি
On the list, item number 1.
I am for the petitioner, my
Lord, I am
lord.
appearing for the
Petition, my lord,
feasibility.
your lordship, my lord, on 25th March, my lord, 2025, my lord.
It is it.
Your lordship passed an order, kindly see the lord. I have communicated, my lord. All are communicated, my lord.
Where the report I am placing before your lordship.
একটা কপি দেবেন হ্যাঁ
Well, on date to দিতে বলো। The petitioner is entitled to get 3,79,603. And my lord, I have instruction that it will be cleared up within 8 weeks.
Outstanding is 3,79,000. You clear it within 8 weeks.
It will be within 8 weeks, it will be cleared up.
মানে along with interest, my lord, because my lord, earlier bench, my lord, they have also, my lord, give the, my lord,
Sir, I repeat to your lordship, because of this.
Then let them file affidavit. You file your reply. Everything go on for
no,
next.
no, my lord, no, my lord, kindly see, my lord,
Sir,
no, no, no.
all right. File your reply.
No, no, no.
File affidavit.
No, 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 my lord. Kindly,
What do you mean? No, no, no. I'm not sitting here to ensure every nook and payment of yours. They are willing to make the payment. I'm not getting into
from
disputed things.
2018, my lord, he is suffering, my lord. So, my lord, with interest, my lord, some interest, my lord, some
Sir,
interest.
sir, are you making any interest? Are you paying any interest on it?
Well, may I be frank to your lordship?
Then I'll pass an order. Let the proceeding conclude. Judicial proceeding conclude. Then order will be passed by this court.
Well, minimum interest may be given. I have no objection, subject to
can't-
your lordship.
So you file your reply. Put it on record. It's very difficult to pass orders like this.
On the coordinate bench, my lord, pays the, was the same matter, my lord, same corporate, same municipality, my lord. I mean, they have complied with the direction, my lord.
Or let them file it on record.
But they are ready and willing to pay the principal amount along with some interest, some interest.
How much is the delay period?
2012, 2012 to 2000.
The difficulty is you are seeking interest from which date?
Interest from 2012 to 2014.
That is the difficulty.
Yes,
That is the difficulty. You file your reply. The difficulty is the period has to be very clear. And that calculation has to be done. Otherwise, very difficult to pass an order regarding interest.
Your lordship direct them to file a report, my lord, to the
File it.
calculation of the report, my lord.
They
To
will-
calculation the
No, you file the affidavit with the calculation. Counsel for the respondent has got the status report. The same shall be filed with an affidavit indicating if any interest has been paid on the delayed payments. Full stop. Let the same be done within a period of 2 weeks. Reply to the same in 1 week thereafter. List after 4 weeks.
state respondent.
What state? I'm asking.
State respondent. State के बोले नहीं, वैसे भी बोले.
You file your affidavit. Because we have to see since when the interest has not been paid. Pass an order, I have to see the calculation.
Obliged to alert.
Number 2, Lord, I am appealing for the municipal.
Lord, I am appealing for the petitioner.
I was
Lord.
directed to file the report. But the PPO has been issued on 27 February. Not the accordingly, the PPO proceedings is going on. This is the report.
You appear for?
Municipal, Navadhi municipality.
They are
My lord, kindly see the report. My lord, my lord, they said in paragraph 2 that the family pension will be issued within the month of April 2025. Well, all right. My lord, they are silent about my lord, the gratuity and then the area pension. My lord, kindly see the next page of the report. My lord, the death gratuity is 7,30,000. Well, kindly see the pension amount 0 only with effect from up to my lord, in the third line, my lord, the second line, my lord, net death gratuity 7,30,000.
Yes.
And my lord, kindly see the my lord, the pension if EFP 25,900 with effect from 1st May 2022. They are silent about from 2022 to my lord, February 2025. They are silent about that.
Before issuance of PPO, how can I alert the before PPO?
So this is the area accrued
the area has to be paid, sir.
with interest, my lord.
PPO issued, the thereafter proceedings has been started.
So this
But you have not mentioned anything about the gratuity.
Gratuity also will pay.
gratuity and the area
Gratuity
pension,
also
they are
will
silent about the.
I'll allow them to file their report. Affidavit in opposition, reply, you
My
come
lord,
after
kindly,
5
my lord,
days.
may I pray one thing, my lord? Kindly keep this matter in the next month, my lord. Kindly ask them to file another report regarding the gratuity and the area pension.
Take down. Learned counsel for the
Lord, I file affidavit in opposition.
file affidavit in opposition.
Disclosing each and every fact, and they reply, and thereafter matter will come.
Learned counsel for the
So
respondent
it's a report, my lord, that
corporation has
matter can be disposed of.
filed a report counsel for the petitioner is not satisfied with the report since he says that material particulars regarding gratuity and other payments are not indicated in the report, full stop. In view of the same, learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition, 2 weeks reply thereafter, list after 8 weeks.
3 weeks, opposition 3 weeks. Opposition
3 weeks, 2 weeks, 5 weeks.
My lord, kindly fix it. My lord, kindly.
The last occasion I appeared on 27 March, I appeared, but my name is not recorded. Name Howrah Municipal Corporation. My name is Shapun Kumar Mujumdar, Navaddin Municipality. I appeared for Navaddin. Kindly direct it for correction.
Mr. What is your name?
Shapun Kumar Mujumdar.
Mr. Shapun
Advocate
Kumar.
for Navaddin
The
Municipality.
order dated so and so indicates that Mr. Majumdar's name is inadvertently missing from the order sheet. Necessary corrections be made. Full stop. The order dated so and so
Tenant.
stands modified to that extent.
Attend में छुट्टी है इसमें? Grateful to you.
Item number 3.
Lordship, I am appearing for the petitioner. This matter was heard by your lordship on 24th March, and there was a direction of the file.
Upon the HMC, your lordship, to inspect the property, both the properties, and then file a report. I'm seeking for some more time.
Ms. Sonal Sinha appears for the, you appear for the corporation?
Yes, for the HMC.
Corporation and seeks some more time to file her affidavit in opposition.
Report in the form of affidavit. Any
Report in the form of affidavit. Full stop. Seeks how much time? Ms. Sinha, how much time?
4 weeks minimum, your lordship.
4 weeks time to file her. So and so. Reply to the same if any exception or replies to the same if any within 1 week or 2 weeks.
1 week, lordship.
1 week thereafter, list after.
Since there was a query from your lordship only. Grateful.
तो ये ले लीजिए.
Item number 4.
I'm for the petitioner, my lord. My lord, this is my affidavit of service. Services effected upon all the respondents.
I am for the state, my lord.
My lord, the private testimony number 5 started unauthorized construction, encroaching some portion of the public road.
Who appears for the corporation?
Mr. Shonang Bhattacharya is to appear for the Association Municipal Corporation. I have made a representation, my lord, 25th January, but did not consider. They have projected some portion of the first floor and second floor over the public road.
Serve them again. Nobody is here.
Upon the Association Municipal Corporation.
They are the respondent. They are the main answering respondent.
my
sir.
lord.
Learned counsel for the petitioner shall serve upon the respond number
5.
Respond number 2. That's it. No affidavit of service is taken on record. None appears for the. No, that's 5 is private.
5 minutes. First postal article came back with
Sir, 5 is a private party. I'm
Private
talking about
respondent.
municipality.
municipality, my lord, 1. 1, 2, 4.
1 to 4. Shall serve 1 to 4 of list after 1.
Okay.
Item number 5.
And I am for the corporation. Last occasion, I am also told, my lord, no copy has been served.
Your lordship, I am appearing for the petitioner. Your lordship, I need to take instruction from my client. I could not able to connect him. I am praying for not this week, your lordship. I'll come with instruction in the meantime.
What is the matter, madam?
Your lordship, There is a order by this honorable court for demolition of unauthorized construction. My client is residing adjacent to that unauthorized construction as a tenant under the ownership of respondent number 6 and 7. So municipality is also proceeding to demolish the premises where I am residing, your lordship. So that is my grievance.
Copy. Why you have not given a copy to her?
Today itself I'll give the copy.
Last time also I had asked you to give the copy.
Yes, my lord. No one appears last time, my lord. Petitioner for petition.
Supply a copy.
Yes, your lordship.
When do you want? Tomorrow?
Lordship, not this week, your lordship.
Why not this week?
I need to take instruction from my client. Your lordship.
Instruction in one day, what is the difficulty? What is the difficulty in taking instruction?
I could not able to connect him, your lordship.
Then
That is the difficulty.
leave the case, he's not interested. He should connect with you. You should not make so much effort after 2 days.
Your lordship, kindly not this week. I'll come with instruction.
Not this week.
Gratefully, your lordship.
Can I?
Give her a copy. It's not even maintainable. He has come against no cause of action.
Yes, my lord.
Not maintainable. It should be dismissed.
Dismiss, my
There's
lord.
nothing in this matter.
Next day, my lord.
Not even no demolition, nothing is in anticipation. He has come here. But just
Either copy not, sir, my lord, then I.
a copy. So she'll serve it. If you don't serve a copy today itself, learned counsel for the petitioner undertakes. This court had given a direction to the learned counsel for the petitioner to serve a copy of the writ petition upon the respondent. Till date, no copy has been served. Counsel for the petitioner undertakes to serve the writ petition, copy of the writ petition on the respondent during the course of the day today itself.
Grateful.
Item number 6.
Yeah, your lordship, I appear on behalf of the petitioner, your lordship, in item number 6. May I seek for a knock today, your lordship? This was that matter whereby I made a representation for asking a death certificate of my client. Your lordship, I kindly request the matter to be taken up tomorrow at any time, your lordship.
But why? What is the difficulty?
Your lordship, I am out of station, your lordship, and I am not carrying the brief, your lordship. I am in a bit of predicament today.
You appear for the corporation?
No, my lord, I'm appearing for.
I'm for the state. What happened to his death certificate?
My lord, your lordship kindly consider my lord, the death was occurred in the year 2015, my lord, and the application has been made in the year 2024. My lord, there is a provision in the Death and Registration Act, my lord, that my lord, within 21 days, the application has to be made, my lord, and the maximum limit is 1 year, my lord. And another thing, my lord, the petitioner is not the family member or near relations of the deceased, my lord.
Your lordship, I'll satisfy on both these rounds, your lordship. Probably my learned friend is not properly instructed. Your lordship, allow me to come back tomorrow, your lordship. Just tomorrow. Just today, your lordship. I'm paying for a knock. Because I'm not kind of you, I will not be able to assist your lordship.
Not
grateful.
Item number 7.
My lordship, I'm on behalf of the petitioner. My learned senior is on the way. Kindly pass over the matter for some time.
Start. What is the matter about?
Yes. I'm for the private respondent numbers 9 and 10. Allegations are against.
Start, sir. What is the matter about?
Actually, I got this brief today morning only. Actually, my learned senior is not elaborate about that. Actually, that's why I am.
Read the brief before you come to the court.
Yes, my learned senior instructed to do some passover. Kindly, your lordship, pass over the matter for
Who's the
some
senior
time.
counsel?
Yes, Mr. Rasin Singh.
Not today, then we'll have it tomorrow.
Can it be on Wednesday then?
Wednesday.
I'm so grateful.
Gratefully, Your Honor.
That's it, sir.
Well, Item number 8. In this matter, initially due to urgency, this matter was moved and on 24th July, adjudicative order of status quo was passed. Where the tenants under the property, another construction is going on, and despite the municipal authority without taking steps to demolish the under construction, try to demolish the subroom, which is solved. And accordingly, can 6, can 6 is my can 6 is pending. If you lost can 6 for extension of engine order. And 24th July 2024, the order was passed, and time to time, this order was extended by the sovereign. And one of the last extension was made within time, the application was filed before this ombudsman. Last extension was 7 January 2025.
There's a settlement arrived at.
No.
Yes,
The settlement was there,
Then
but they will give us all the petitioners said they will allot us up. They will give us.
yes.
But subsequently they said they shifted their stand. They said now only petitioner will allot it. Other petitioner will not give this up. Despite of the order, there is an order of the kindly have a look to the page 157. This matter was referred to mediation. I have annexed the my extension petition. I have annexed the mediation order. The settlement which was arrived at the mediation at page 90, final report of mediation as can 6.
Can 6 to the can 6 to the can 6.
And 6 to dispute of the
No. Can 6 to dispute of can 3 to pin.
Yes. Which can?
Can 6.
What is can 6?
Can 6 for extension of entry order and another pair was made for appointment of one of the special officer. Because
For what?
Till date, my lord, the analysis construction is going on. Till date.
No need
Plan
for
has
any.
already been, my lord, not being extended. Plan has already expired, life. But in spite of this is the photograph, my lord, 2 days before they have taken the photograph, the open space, my lord, they have been started construction illegal. Again, analysis construction is going on.
Whether the increment will be continued or to hear
The first, my lord, the addition on the page 12 is the initial order for this HON'BLE court on 24th in 2024. Then time to time that was extended. Then the mediation at page 19.
as per order of the
Final report of mediation on 5th November 2024. দেওয়া আছে না এই কপি তো দেওয়া আছে প্ল্যানের কপি তো দেওয়া আছে
Supplementary review.
হ্যাঁ দেওয়া আছে আপনার না দিতে
Yes. So what happened after the mediation?
After the mediation, they have shifted their stand. Well, they are now saying that they will only, the petition, they will allot problem only to the petition number 1. But remaining 5 petitioners, they don't have anything, they will not. It is
But
their
I have-
stand.
I have
But
already-
the most unfortunate thing is, the matter is going on before this Honorable Court. This is the recent photograph. The open space they have taken, they have started, well, the another construction is going.
But as per
The
mediation,
unfortunate part, well, this is going on. Despite the matter is pending before this Honorable Court.
Mediation specific
but as per mediation, we have deposited 10 lakhs rupees, my lord, for this report. And my lord, we have constructed, my lord, a temporary construction as per the direction of the honorable
This
mediation.
doesn't show anything.
My lord,
This doesn't show anything, sir.
there are 6 pages.
It is here.
Yes,
They have
ma'am.
also annexed it.
এইটা পেজে আছে না সাপ্লিমেন্টারি দিয়েছে
That is only one he is showing, but I made 6.
No, he is not agreeing to it. He is saying you have done nothing. He is saying,
So, my lord, your lordship will find that I have complied with all the terms of the mediators. my lord.
mediation report
Nothing else.
May I
Your
read
lordship
the
will find
mediation
your-
report?
your-
Mediation report.
I have read it.
May I read the mediation report?
I have read the mediation.
But they have now shifted their stand. They want to, my lord, the other construction will be going on, they will carrying on the other construction. They have taken, my lord, the no objection from us for getting permission from the corporation for construction of the building. Then they started the unauthorized construction.
without
We moved before the honorable court. Then, my lord, they started demolishing of our stop. Then we entered before this honorable court, moved before this honorable court and obtained an interim order. In spite of that, thereafter, my lord, time to time matter, the executive order was extended. The matter was referred to the mediation. In the mediation, they stated all the shop owners, they will allot the shop. Particularly within 15 days, they will arrange other place for shifting of the shop room of the 6 petitioners. Thereafter, when the matter was taken up for hearing before this honorable court on 7 January 2025, they changed their stand. Now they are saying, no, I will give only one, not to the other.
Only the petitioner of one. He is having one shop roof, having one portion in the unauthorized portion, and other portion is it is existing shop roof. We have nothing to say about that. But the corporation has made this objection that his shop roof is outside the sanctioned plan area. So you demolish it and giving him free. We are ready to that, but for that demolition, he will have to vacate that. In the mediation, my lord, he said he is ready to vacate that one. Accordingly, my lord, we made this temporary tin sheet constructions.
How many shop owners are there?
6
My lord, there is only one shop owners is left. Others are demolished as their construction, their alternative accommodation is.
You are appearing for one.
Sorry.
In the red petition, how many shop owners are
One
there?
to six.
We have 6 shop owners. We have arranged the agreement with the owners. The owners come promoter the respond number 7. We have arranged all the agreements. They said, with the no objection, we will allow the shop. That is their condition. In the mediation, they have also stated that.
Even in the mediation, you have said that.
My
You
lord.
read your mediation report.
My lord.
Read the mediation report, sir.
Yes, my lord. My lord, one thing, my lord. They are claiming their shop owners. What I said, that they have their rent receipts. In the rent receipts, their areas is mentioned. 3 by 4,
5 by 4 is not the shop owners, my lord. These are stall owners.
Sort your dispute before you come to the court. You can't sort it out, let it continue.
My lord, I'm reading out this my report, my lord. Reading out this.
Read it.
The responsible concerns are present. The efficacy, utility, mediation process is discussed and said we are in presence of them. After prolonged deliberation since the other day, it is heartening to mention that the parties have voluntarily buried the hatches once for all in view of the following terms and conditions. This is in number 7. That is, I am the owner of the property, my lord. They are my tenant. This under 7 shall construct new construction strictly in accordance with sanction plan granted by KMC without making any departure there whatsoever. The respondent number 7 in the meantime shall arrange a covered shed within close proximity of case property so as to accommodate all the businessmen, be a shopholder or a vendor or an occupier running business under the open sky therein. So, my lord, there are 3 categories of tenants we are having. All such persons, that is occupiers, petitioners, shall forthwith vacate the premises of their occupation except origins of the petitioner number 1. He is having the shop room, my lord. In doing so, respondent number 7 shall deposit within a week 10 lakhs rupees positively at the office of the Registrar General High Court, Calcutta, as a security and guarantee to prove his bona fide that surely he will make new construction, accommodate all the persons who are in occupation of the premises. The respondent number 7 shall accommodate all such shop owners and business persons inside the premises of new construction made according to sanction plan of KMC. Respondent number 7 undertake to keep the premises of the petitioner number 1 inside the sanction plan area because his existing shop room is partly in the sanction area and partly outside the sanction area. This respondent number 7 all such exercises shall be completed within a period of 4 months hence. In case of complete rehabilitation of the petitioners in the newly constructed area, the respondent 7 shall be permitted to withdraw his security deposit of 10 lakhs. A request letter separately be sent to the Registrar General High Court, Calcutta, to take security deposit of the said amount as mentioned above and return the same as soon as the completion work will be over. I also make it clear that no one concerned shall cause any impediment in the construction work to be undertaken by the respondent number 7. As soon as the rehabilitation of the business, all businessmen will be complete, the temporary tin shed shall be dismantled and the position shall be restored empty. The respondent number 7 shall arrange the temporary shed for shifting the present occupiers within 15 days and hence within 3 days thereafter all occupiers including the petitioner number 1 shall vacate the premises so as to enable the respondent number 7 to undertake the construction work. I make it clear that the dispute shall stand settled once for all. There shall not be any reopening of the dispute in future in any manner whatsoever. I also make it clear there is no such provision of appeal against such order. In case anyone flouts or does not abide by the terms, the case shall be returned to the Honorable Court as non-settled case. My lord, in my endeavor, my lord, I made these tin sets. Your lordship will find there are 5 tin sets are there. Some of them have already been shifted there, and we are making that replacement, my lord. Out of the 6 petitioners, only 1 petitioner is left, that is number 1, who is having a shop room, existing shop room from the previous building. It is not a new construction, it is an existing building. His shop room, my lord, and others they are not shop owners, they are stall owners. And
they have already moved out.
They're televendors.
All have moved out, only one. One of your petitioner is creating all the problem.
6 persons is there. But from the mediation report, my lord will find that he himself.
Sir, have others moved out?
Not moved out.
All are there.
Their substance have been demolished by them.
You have given a permission for them to be demolished?
No.
You gave NOC?
No. Yes, we have given the NOC before the sanctioning of the building. After that, my lord, we moved people to the Honorable Court. That time, my lord, the interim order was granted. when, my lord, the 1 and 2 days, my lord, we have filed the application, court was not sitting, that event, they demolished 5 shops.
Good.
What is there?
That is
5 shops, and my lord, I have annexed, I have not, no. That is why I have also issued a contempt notice upon them.
I have
They are
enforced
in
all the
league.
orders, my lord.
They are in league with the in coalition with the corporation authority. They have constructing unauthorized report is there also, my lord. My lord, page 157, my lord, you find that there is an unauthorized construction report of 2023, page 157. My lord, 3.5 half-story building, they have completed fourth floor. Open terrace, my lord, recently they covered the open space by started again unauthorized construction. They are only aimed not to give us the shop. In spite of mediation, they have stated they will allot all the shop owners, all the 6 petitioners before your lordship, they will allot the shop. Page 157, my lord, kindly see. This is up to 2023, especially with the building report in compliance with the order passed by this honorable court. There is an infringement in 2023.
Who appears for the corporation?
Madam, in this matter, Mr. Holocaust is appearing on behalf of the corporation and he has not come to court today. And this is the position. And he has not personal difficulty, he could not move.
We'll have it tomorrow. When will he come?
Tomorrow he will come.
Tomorrow?
Yes, sir.
My lord, my CAN 3 is waiting, my lord.
My lord, I am
My lord,
tomorrow.
Probably the CAN 3 is not here.
My lord, I am paying leave to
CAN
file.
3 is not here with the records.
Supplementary ability to file court now.
My lord, I am paying leave to file two supplementary evidence. One containing the building plan, sanctioned building plan.
No leave right now. Let me see the file tomorrow. Your can is not there. Get it placed.
It's not there.
That's your responsibility.
Can number 3, my lord.
Sir, that is your responsibility if your can is not
Long
there.
time back, I have filed it. Last
So
time.
that's your problem.
No, my lord, last time when it appeared, my lord, I find that the can was not there. That's what I'm saying.
Put it on record.
CAN 3.
Probably, my lord, can see disposed of with can 5.
No, cannot see. CAN 3 is not disposed of.
Can 3 days dispose হয়ে গেছে দেখুন না order
CAN 3 not disposed of.
Can 3 is there.
can 3 and
It's on record.
No, can 5.
ये फाइल आज भेजना जरा.
can 4
Can 3.
can 3 টা pending
Pending at the beginning.
pending
Public.
Not today.
not today করেছে নাকি
তো নামটা রেকর্ড করে
না না
My lord, may I be permitted to mention, I'm compelling circumstances I'm mentioning. Item number 7, I was on, when the matter was called on, I was on leg before another court. Your lordship was pleased to fix it on 9th. My lord, on 9th, I will not be here. So if your lordship kindly fix it on any date after 9, I will inform the other side.
I will not mention matters like this, sir.
No, I beg your pardon.
Don't.
I beg your pardon.
Please don't.
My lord, item number 9, my lord, I am. My lord, appointed as the special officer by this honorable court, my lord, on the last occasion. My report is already with your lordship's record, and I have soft copies, my lord, upon the municipality as well as the petition.
Lordship, I am for the municipality, Lordship. Lordship, the special officer report is incomplete, Lordship. I will indicate the point, Lordship.
As per special officer report, there was an encroachment by the municipal authority.
No, Lordship.
On my land, the sewer
No, Lordship.
pipeline is going in.
Where's the
No,
where's the
Lordship.
report?
Hey, এটা নিন না।
No, where's the report?
My lord, report I have filed, my lord, on the last occasion.
Is there any encroachment?
My lord,
Is there any encroachment?
my lord, as per the site plan which has been annexed in the writ petition, there is a partial encroachment. But my lord, on physical measurement with the help of a surveyor, we found, my lord, that presently the pipeline is outside their property. But according to the site plan they have annexed, it is encroaching. My lord, I have annexed.
We don't go by their site plan. We go by whatever.
Lordship, physical, Lordship. That is the report, Lordship.
My lord, that also I have, if your lordship kindly comes to, my lord, page 7. Page 7 of my report, my lord, or of the report of the surveyor, which the court permitted to take along with the special officer, my lord. May I read with your lordship, my lord?
Yes.
My lord, I have, this is the, my lord, the survey. I have measured the plot of land located at holding number 1861 So such and such, my lord, chain number and not disturbing the lordship, so move just went so. On 18/1/2025 and found it to be 1 kata 12 chota 12 square feet is equal to 118.155 square meter is equal to 1272 square feet approx. On the basis of such measurement, I have prepared a site plan and the boundary is marked with red, hereinafter referred to as site plan B. I have also been given a site plan and the boundary is marked with red, hereinafter referred to as site plan A of the aforesaid property, which is part of the sale deed. According to site plan A, the measurement of the property is 1575 square feet. An underground municipal pipeline is running along west side boundary of the property. As per site plan B, outline marked as red, the pipeline has not fallen in the land, but as per site plan A, the municipal pipeline is partly encroaching the land. My lord, site plan B is the physical measurement and the site plan A is what if they are done.
Lordship,
I have
the
analyzed-
physical measurement, Lordship.
Just now I received the report from my landlord, but I will take one day.
Just give it now.
Yes,
My lord, because my lord, initially when I submitted this report, I have given it to the municipality. She was not there, my lord, so I could not.
One day I will take it.
Lordship, may I apprise only one photograph? Lordship, it will clear everything.
I have annexed the photographs also.
Keep it on Wednesday.
My lord, I am dispensed with or I will.
No, you will come here.
Deeply
Day after,
Lordship, kindly pass in short order, Lordship.
day after tomorrow, nothing, no order can be passed. Day after.
deeply observed.
Nine.
No.
Item number 10.
আপনার
10 and 11.
টাইম নিচ্ছে
Lordship, on the last occasion, there was a direction to file this an affidavit in exception. Lordship, my affidavit in exception said, but it could not be affirmed due to some personal difficulty on the part of the
Speak in the mic. What are you saying?
Lordship. There was a direction to file exception to
The mic is not working or what?
My lord, item 10 and 11 is together, my lord. What has happened?
10 and 11 are taken together.
Yes.
10 I am for the item number 10, I am appearing for the petitioner.
And 11, I am appearing for the petition.
Appearing for the respondent number 6. On the last occasion, there was a direction by His Lordship Honorable Justice Procedural to file an affidavit in exception to the report of the special officer. Lordship, my affidavit in exception is ready, but it could not be affirmed due to some personal difficulty on the part of the petitioner. Lordship, I am praying for a week's accommodation. In the meantime, it will be affirmed.
My lord, only one submission, my lord. May be permitted, my lord. My lord, on the last occasion, there was a direction upon the KMC for inspection of the property, which has been held last week, my lord. They, your lordship, if your lordship sees the last order, my lord, they were also directed to file a report.
But this is the report of the Kolkata.
But let the report be circulated, my lord, so that we can, my lord, have a look into it, my lord, and come back before your lordship, my lord.
Just give the report.
Sorry, sir.
The
I petitioner item 11. Deben?
report is filed by the Calcutta Municipal Corporation. The same is taken on record. A copy.
I am for the item number 11, man.
Item number 10, I have filed the report.
Item number 10 not. And the copy of the same is circulated to the party.
Petitioner in here.
Full stop.
দিয়ে দিচ্ছি দিয়ে দিচ্ছি
Petitioner, you are in item 10.
Item number 10, and
Petitioner states that the petitioner seeks and is granted 1 week time to file his exception to the special commissioner's report. Let this matter be listed on after a week.
এটা নিয়ে আমাদের লাভ কি আছে
After a week.
circulated the report. Item number
My lord, item 10 report has been circulated, my lord.
Have stated. It's recorded in the order.
But if I get a report of the fiscal officer,
I have already, my lord, I have already
My lord, only one thing, my lord, in
Hold on.
respect of item 11, a report was supposed to be filed by the KMC.
Item 11, I am for the KMC. Let a special officer report be served on the KMC.
Yes, yes, I have already
তুমি 10 দিয়েছো 11 দাওনি
দিয়ে দিয়েছি আমি দিয়ে দিয়েছি
তাহলে একটা কপি দাও কি বল তাহলে এটা কপি বি গিভেন
You give a copy.
already served, my lord.
In item 10, you have served. He has
11
got,
not.
Mr. Mukherjee has got it. Mr. Banerjee doesn't have a copy.
Yes,
So give a copy to Mr. Sandeepan Banerjee.
Yes.
Okay, in item 11.
Yes.
You were supposed to file a report also in 11.
I have to file an exception regarding that.
No, not only
Yeah,
inspection.
yeah.
There was a
Exception.
direction for inspection also.
Inspection.
Inspection in 11.
11
Because
we have made
my
a
learned friend's property was to be inspected.
inspection. We have filed a report already. Special officer has filed a report regarding.
Your report is already here.
Yes, that is always there. It's there. And so far as the exception I have to file now, which are they are going to let them give a copy. I will serve a purpose. Only 2 weeks may be given.
My lord, then my lord, your lordship keeps it in May. My lord, I have some personal difficulty, my lord, from 21st. My lord, I will not be.
But you're getting married.
No, that is already ready for him, my lord.
Honeymoon.
Not for me.
No, my lord, that.
Mr. Banerjee objects to the person. I have not given a card to Mr. Banerjee.
My lord, wait, I'm just prepared it, my lord. I'll circulate it to 2 days.
We'll have it in May then.
Yes, my lord.
When are you coming back?
But first week of May.
Listed in first week of May.
একটা কপি দিয়ে দাও গো। দেবে দেবে।
11, sir. Connected matter. 11 में you can just say that वो first में 10 में वो रिकॉर्ड था ना 11 में क्या ना counsel for the petitioner KMC for respondent KMC is handed over a copy of the report of the special commissioner. He seeks 2 weeks time to file his exception to the same, or 4 weeks time to file his exception to the same. Now it's listed in 3 weeks हो जाएगा May 1st week में 3 weeks. हाँ ठीक है.
Agenda number 12.
My lord, I am appearing on behalf of the petitioners. I am led by Mr. Vishnu, but I am praying for a short pass.
My lord, I am for the private respondent number 6 and 7. I need to file affidavit in opposition, my lord.
Yes, sir. I am on behalf of the private respondent number 11. But I have filed an application for addition of party because the respondent number 11 was made of party after knowledge that she was died in the month of March. The petition was filed in the month of July.
Sir, কোন মামলাটা বলছেন?
I am appearing on behalf of the corporation. Manner, I want to file the opposition.
My lord, in that event, my lord, there is an application for extension of interim order. May the interim order be extended.
Where's the order?
My lord, it is annexed with the application for CAN 1, my lord. It is annexed with CAN 1. Page number 8.
What is this unauthorized construction?
My lord,
In the third floor.
my lord, a gym is being run without proper permission in a residential premises.
No, my lord, there are several papers are there. I need to file
My lord,
affidavit in
I'll show you,
opposition.
Lord.
Civil suit is also pending injunction granted in favor of me. But I have to show all
Well,
these
I
things
also
by
show
filing affidavit in opposition, my
that
lord.
such gym cannot be run.
It is for the corporation to decide, sir. You go show all your documents to the corporation.
My lord, already shown them.
Although the hearing was already being
Well,
done
there was
by the special officer building.
They have given it a hearing
The
also.
order was there annexed with the petition at page 306. The parties had paid for the conversion of the second floor.
My lord, not the parties. My lord, I had objected to the conversion of the residential premises into a gym. Whereas my lord,
I'm paying commercial taxes also. There is a change of assessment role for user changes.
my lord, that has been disputed and an appeal has been preferred from that order. That is pending, my lord. They have
AMC already passed
they have my lord,
revision order,
seek
my lord.
time on 2
That is-
occasions in the court below. My lord, may kindly come to page number 44 of the writ petition.
Deed, my lord, is clearly written there to use that premises for the residential purpose and also not to convert the structural alteration.
How did you allow it?
Before the corporation, my lord, in the hearing.
My lord, that is.
My lord, not suppressed. My lord, already I have intimated the KMC for user changes and for running gym.
So
in
recall
said
the order.
premises.
You recall the order. Why don't you recall the order which you have passed?
It's running in the court that time. If I go through this order, I have.
My lord, there are several writ petitions
My lord,
there
if I
and
may-
written order passed by the KMC, and we are ready to pay the conversion charge.
It doesn't matter. Why don't you recall the order?
When I have go through this deed,
I
my
can
lord,
record that submission that you will give a hearing. A fresh hearing will be given.
My lord, my clients are senior citizens, my lord. Their sleep is being disturbed every night.
Do you follow what I'm saying?
My lord, yes.
Then why are you making submission? Yes.
Direct for the fresh hearing, we are ready for.
So what direct? I'll say that you are, since documents were not produced before you and you had passed an order without looking into the other documents, I'll give you liberty.
My lord, all documents are given, my lord.
Sir, I will go by the statement of the KMC.
Yes, my lord.
Okay? I'm not going by your statement. I'll record it. So, which page was the order?
Page number 8 of the CAN.
What is your affidavit in opposition?
Affidavit proposition नहीं दे दो।
Paragraph 13, my lord, I have just annexed the SOB order. Special officer.
Here, your affidavit is entirely different. In the affidavit, you are saying that whatever is being done by the respondent is in accordance with law.
Executive engineer has pointed me that paragraph in the deed.
You will be in trouble if I record that. To file an affidavit in opposition, you withdraw this, file a fresh one. If I record it, you will be in trouble. Who's there? Anybody to give instruction from the corporation? Okay. If I record this without any instruction, then they'll put it on you. As a counsel, you'll be in trouble. You file an affidavit in opposition with whatever you're saying. Don't file this. I'll give them more time.
May the interim order be extended?
Where's the interim order? Which page?
My lord, give me liberty to file affidavit proposition in the next hearing. My lord.
The can 1, my lord, page 8.
Can 8.
Can 1.
Can 1.
Page 8.
Why you have made this petition so bulky?
Several documents, my lord, various rounds of litigations, all have been annexed. My lord, I'm led by Mr. Principal.
Sorry. Lot of issues, she just now, the counsel for the corporation, Mr. Bhattacharya says that she has realized that in the sale deed, she says that in the sale deed, the property could have only been used as a residential premises. But the affidavit which she has got, they have justified the usage. So I'm giving her opportunity to file a fresh affidavit in opposition.
Not only kindly visualize, me not. So
I have visualized.
a gym is running in a residential building. And gym, kindly, we know, of places in Calcutta where people visit the gymnasium maybe at 11 o'clock in the night also. 10:30, post work. So, kindly, this situation has to be arrested, somewhere. It has to stop somewhere.
No, I completely agree with you, Mr. Bhattacharya.
That kindly, protect us. We have been, in the previous bench, the coordinate bench, was kind enough to pass an interim restraint order, in restraining them from depositing the fee, whatever was calculated, for regularization of this.
We'll extend the stay.
Fine. You will find by clearance, yes.
Today you are not running the gym, right? You're not running the gym.
They are running the gym.
My lord, we are running that. We are running that.
You're running it?
Yes, yes.
Stop running it. Take down. Learned counsel for the respondent corporation has filed an affidavit in opposition. Though she states that after perusal of the document, the department has realized that the sale deed itself records that the building was purchased for residential purpose. and that no commercial activity would have been allowed. Full stop. She states that she wants to file a better affidavit in opposition, bringing on record all necessary better affidavit, bringing on record the clear stand of the corporation. Full stop. Since when are you running the gym?
My lord, after 3-4 months of purchasing of this property and getting
No, there was a stay.
Stay to the extent of,
uh,
I'll just show you.
or-
Now, please come to the impugned order once. Page
regulation order.
305, 306, kindly come volume 2.
Yes.
Now, considering the statement of both the person responsible and complainant, I am inclined to pass order to retain the deviations with change of use as marked in such and such on payment of fees under 4001, 400 subsection 1 and 416 to be paid by Piali Sarkar, that is my learned friend's client, for the second floor change of use, and Shujit De for change of use at the ground floor, and first floor as marked in such and such, which must be paid within 30 days. To that extent of Piali Sarkar's payment, we could persuade the Honorable Court to grant a stay, that they will not be able to pay the fee. That is the stay order. Insofar as operation of the gym, there is no stay.
That will not help you then.
That doesn't help us.
Let them file their let them file their reply. Let them file the affidavit in opposition. In terms, because they are saying that they themselves realize that the order which has been passed earlier.
Only one
impugned order. They are saying the impugned order is not rightly passed.
Then they'll let them revisit the entire thing. Your Lordship relegates it back to them.
Let her file it.
Very well. Very well.
Difficulty is there is no person to make that statement. If I put all this, Mr. Bhattacharya, you understand? If I put this on the council.
No, 100%. But I don't say. Your Lordship is correct.
So that's why I'm giving her an opportunity.
And as your Lordship. A short date may be given, if it comments.
How much time? 2 weeks. 2 weeks. You want to file a reply to that? Reply, if any, within 1 week. After 3 weeks, we'll give.
That will take the matter out of
After
court.
2 weeks, you want?
Let us come back 2 weeks hence. If we intend, we'll do the affidavit here.
After 2 weeks.
Let an advance copy be circulated.
With an advance copy to the parties.
Great.
You take this back, madam.
Now, this is the affidavit of service.
Affidavit of service is taken on record.
Grateful to your Lordship.
My lord, Diwati given me to give me affidavit in service. My lord.
Why do you want to file your affidavit of service?
My lord, kindly give me some opportunity, my lord.
No, he wants to use an affidavit in opposition.
Yes, my lord.
For what?
He has not questioned the order.
Ascertain all the things, my lord. There
The order is already
so many
there.
documents, my lord. I will.
What document? You already have. We'll see that. Let the
Give me the opportunity. I will.
Let the corporation first file it. We'll see. And madam, you put your stand. Withdraw this order.
Yeah.
All right.
Great.
Item number 13.
So, Mr. Bhattacharya, tell me one thing.
Sorry.
These in Calcutta or in rest of the corporations, do we have any layout plan, subdivisional plans, or anybody can do anything in any area?
Not that. It is.
Are there any areas which are prescribed as commercial area, residential area? Because I see all activities being carried out everywhere. You don't have a master plan. Do you have a master plan?
There
No,
was
not Kolkata. I'm talking about,
That he will know better. He has been appearing for the KMD and the corporation.
there was a master plan, my lord, of British era.
Yes.
After that, there's a master.
After that, there was no such plan because, my lord, the Calcutta itself is an unplanned city.
Yes.
With the passage of time, my lord, it has grown up with the areas. Earlier, my lord, there was only
100 words. Now that the Kolkata Municipal Corporation has 144 words. But time and again, with the passage of time and with the
No, but you understand, the question is falling only because in residential areas also, you are carrying out commercial activities, like running of a gym.
My lord, the peculiarity of the population over here, my lord, the carrying out the business activity, no specific zone is there.
No,
But no specific zone is there. Only, my lord, only one thing, my lord, can say that this Dalhousie area and this High Court, all these things, this area has been described as central business district.
Okay. So anybody can do anything anywhere.
Yeah,
With permission.
subject to some,
With permission. There is, the regulatory mechanism is there by the corporation and the local bodies.
But with permission, if certain activities are not permitted, then they should not allow it.
Of course, 100%.
Activities, is it enlisted somewhere?
It is enlisted, the activities, for which, permission is to be taken is there, it is there in the municipal acts.
Many schedules are there with the appended with the Kolkata Municipal Corporation. What can be done, what cannot be done, what sort of things, what are the provisions? Those are there. It's not that it is not there. Those schedules are there. And from time to time, with the need of time, some circulars are being issued by the Kolkata Municipal Corporation.
All right. Thank you, Mr. Bhattacharya. Just wanted to find out how the city runs. Very haphazard.
Same is for all over.
Not at all.
Only one thing I can.
Calcutta alone cannot be blamed. I am not taking any
Mr.
side.
Bhattacharya, no, I'm not saying about blaming. I'm not blaming anyone. I'm just saying that for any planned city, there has to be areas where you are only carrying out residential activities. Like in Delhi, you have zoning. There are zones. There are roads which are defined, which are like maybe 18
Even in
meters.
Old Delhi. The Old Delhi
Old
part.
Delhi is also a specialized area. Even there, the activities are controlled. Even Old Delhi. If you would see, there's a new, the entire area has changed. They have come with a new plan for Old Delhi also.
I will be, kindly pardon.
You should go and see Old Delhi. It has become beautiful.
I will be, maybe rebuked by people. But, it is what happens is, there is so much unemployment everywhere. Unemployment is the root cause. Everyone is, kindly see Grand Hotel Park.
This is exactly what was going on even in that city. But then the master plan changed. They had changed the entire layout plan. And then areas have been decided.
Despite the government trying stringently to regular.
Kolkata with Delhi.
No, I'm not comparing.
The national capital, it has my blessings in many ways.
I'm not comparing. I'm just saying the
Kolkata
activity
is not blessed in that way. New Calcutta is is coming up. You'll also find it Newtown, Rajarhat, and all these things. They are, my lord, entire provisions have been
in Newtown, Rajarhat. I'm grateful to my learned senior friend. That is completely a regulated city. Why? Because it is a new park.
So they are
where your lordship will find even cycling zones are there. They are not regulated park. Unlike kindly visualize, every day your lordship reads in the papers that their raids are being conducted by the police to remove the hawkers from Esplanade area. Despite that, if you travel just now, your lordship will be seeing every nook and corner of the footpath is occupied by the hawkers.
We have the Street Vending Act now, the Town Vending Committee.
Despite that, despite no one is, because the system is such, the situation is such, the government is also at times helpless.
The corporation is trying its level to regulate it. Regulated street vending committee is there in terms of the.
Your lordship will not be able to travel down Lindsay Street by a car.
Walking.
Only
you have to
my
walk.
lord, the original Calcutta is about 9 square mile. 9 square mile. It was in its origin. Now it is being expanded. That is the trouble, my lord. With the time
and the entire Salt Lake is today a commercial zone.
Sharing one of my experience.
Entire Salt Lake.
That's why I was asking this question.
Every block, your lordship will see a coffee shop coming up.
Correct.
On residential properties.
Correct.
Because the old gentlemen who stay there, they can't maintain their sons, daughters, they stay abroad. No one to look after. Every block today has at least 5 cafeterias. Every block, but if not more than that.
See, that is something which should be.
I am not naming the other thing, not my learned. friend Mr. Chakraborty just pointed out something in my ears. My lord, I do not want to say that, but that is also, my lord, rampant.
Did he invite you for his wedding?
My lord, there are many other reasons.
Privileged. A lot of people were raising anguish that they have not been invited.
My lord, there are very justified reasons for him to invite me.
Oh. All right. Thank you, Mr. Fletcher.
Here I am for the Kolkata Municipal Corporation.
Yes.
Can I find my
13, we've been served with a copy of their affidavit in office.
reply
Mr. Shuddha Sattva Banerjee is leading me in this matter, Your Lordship. This matter involves some niceties that would, wherein he would be required to render some effective assistance to Your Lordship. May I just pray for an adjournment today? He's on his legs in courtroom number 14. This matter has been heard out at length by the coordinate bench. It's only up for final hearing.
You file your reply to this.
Yes. We have used an affidavit, my affidavit in reply. They have served it to me.
So they have.
It should be with us, Your Lordship. We'll just file that.
Affidavit in opposition filed on behalf of the respondent. Kolkata Municipal Corporation is taken on record. You have filed an exception to this.
We filed a reply to this.
Reply.
A report.
Counsel for the petitioner states that a reply to the same has been filed by the petitioner. Both are taken on record. Let this matter be listed. When do you want?
Lordship, tomorrow, day after.
No, not tomorrow, my lord.
When do you
Tomorrow I
want?
have some difficulty.
When do you want, sir? I'm
Day
not-
after?
Day after tomorrow.
Day after Wednesday, if it commences to Your Lordship.
9th.
9.
Grateful to Your Lordship.
Petition number 14 to 17.
I'm appearing for the
At
court.
14, I appear on behalf of the petitioner, my lord.
For the petition 17, my lord.
Affidavit in opposition original টা দেখি। Originalটা কোথায়?
Mr. Nagia filed your report. Affidavit in opposition is filed.
Affidavit in opposition filed.
My affidavit in reply has been is ready, my lord. I'll serve it and come back, my lord. Only one thing, my lord. On the last, there was an order in the month of November against which an appeal was preferred by the BMC before the Honorable Division Bench, my lord. The Honorable Division Bench was pleased to set aside that portion of the order, but directed the parties to continue on the basis of the merit before the Honorable Single Bench, my lord. But initially, my lord, the writ petition was filed, my lord. We were the purchaser in respect of a property. Now, my lord, at the time of purchase, we were handed over with a sanction plan as well as the completion certificate issued by the then Rajarhat Gopalpur municipality, my lord. Now, my lord, subsequently, it was seen that when the Rajarhat Gopalpur municipality was merged with the Bidhannagar Municipal Corporation, now, my lord, proceedings was initiated under the West Bengal Municipal Corporation Act, and Bidhannagar Municipal Commissioner, Bidhannagar Municipal Corporation came to the conclusion that the plan which was given by the, on the basis of which the developer has raised the construction is not in their record, and accordingly the same is an unauthorized construction. Now, let kindly takes up I have annexed the sanction building plan, which is at next to P4, my lord, at page 261 of your lordship's brief, my lord. My lord, we'll see the backside of the plan, my lord. Kindly see, my lord, there is a serial number which is written 562 stroke 11 stroke 12.
Yes.
And there is a stamp of the Rajarhat Gopalpur municipality. Now, my lord, on the basis of this, your lordship kindly goes down a bit, my lord. There is the signature of the chairman, Rajarhat Gopalpur municipality.
So what is your stand, Mr. Nag, in this?
But the plan is not genuine. That is the stand.
Okay, let us assume the plan is not genuine. Then what will happen? You
But
demolish it.
We assume that there was no plan.
No, but
The construction is without plan.
so what about if he submits a fresh, like in this plan?
But the difficulty is our statute does not provide us with the power of regularization. Look, there is a notification of the Urban Development Department which speaks of minor deviations. And Milord, I would be candid with Milords, there had been a order passed by the Honorable Supreme Court on this Friday in Bidhannagar Municipal Corporation matter, which the Honorable Supreme Court exercised its power to do complete justice and made that order, Milord, where the excess amount, which was less than 15% of the building sanctioned building plan, which was illegal, that was directed that in the market value, a cost will be paid to the corporation. But Milord, here, firstly, the plan is not there in entirety. Secondly, we do not have a provision under the statute to consider a as-made building plan to see and approve. That power is not with us.
So where will the person go?
Well, we have filed an FIR on the point that the plan submitted by them is in contravention to the records of the Bidhannagar Municipal Corporation, which the corporation succeeded from the erstwhile municipality. We say that the plan is a forged one, and we have proceeded in a FIR, Milord. That is the thing we have done. And now, Milord, in the legal position, a forged plan is a no plan.
That on the basis of the forged plan, as alleged by my learned senior friend, my lord, the erstwhile municipality has issued the completion certificate, which is at page 262.
That is also
there.
forged.
That's also forged.
Yes.
My lord, now today, my lord, presumingly if it is manufactured, this person who has signed as the chairman or whoever may be that person, but what steps has they taken against those persons? Because we were not there. We have purchased in the year of 2022 onwards. Now, my lord, the building was there from 2014 to 2022. At that point of time, they did not feel that the building is illegal because the so-called plan is forged. Now, my lord, thereafter, the order impugned, which is at page 324 of your lordship's brief, has been passed on 11/5/2023.
Seems to be.
My lord has got page 324, my lord. The order impugned, my lord.
Department of
Both of them seems to be unauthorized. 3 and 4 both. No.
Even for the completion certificate, you have filed an FIR?
Milord.
You have named whoever was the mayoring council or commissioner.
Chairman. The
Milord,
chairman
subject
of
to
the
correction, Milord. Here, the petitioner is trying to make out a case as if the construction has been made by the chairman of the municipality.
No, no.
It is not the chairman. Milord, he has produced a plan which is forged. So the chairman is a victim here. The chairman is not the accused here. And Milord, subject to correction, it is the responsibility of the person concerned who desires to make a construction to obtain a plan and thereafter construct. Milord, I will not shy away from making a statement that we in the entire state, Milord, not even perhaps for West Bengal, other states also, for the municipal authorities with their staff, it is actually not possible to physically monitor every construction going on in every corner of the society. But whenever there is a complaint, Milord, we act.
No,
There
that's
is-
not the correct statement, Mr. Nagar.
No,
You have deputed officers who are on the ground ensuring there is no unauthorized construction.
Well,
It is
we
the
try our best to do
It is
that.
the responsibility and duty of the junior engineer,
My lord.
the assistant engineer.
No, my lord, that's why I said I'm not
Administrative
shying
engineer.
away. I'm not shying away from your
I don't know
responsibility.
whether you have a baildar here or not, but it starts
No,
from the
no.
baildar.
No, we don't have a bill.
So you have a junior engineer over here.
We have a junior.
So it starts from his. And if we stop fixing their responsibility,
No, no, no.
Right.
I'm not saying that
There'll
we
be
don't have a
anarchy.
responsibility. We have a responsibility, my lord. We try to do the best in our
we are not
capacity,
concerned
my lord. And lord,
only
this is
when
not the first
complaints-
litigation. It is a series of litigations after which we have arrived here.
Who are you? So in all these petitions, the same thing.
Yes, why?
Challenging the same order of demolition here and there.
But we are the purchasers. We have purchased from him. He is the developer.
So he is the person who has.
Who are you?
I am the respondent number 11, my lord. On my objection, on my order of the learned, of this honorable.
It was
court,
his complaint. It started.
So you are the trouble.
Party. When
Troublemaker.
not in this one.
My lord, if your lordship kindly
The
sees.
FIR is against the developer because it is the developer who has given the plan to the purchasers.
Yes.
One thing, my lord. This my lord's question. Is found. My lord, from 2014, the notification was issued against wherein the portions of Rajaghat Gopalpur municipality had merged into the Vidhanagar municipal corporation. But thereafter, in several such cases, this particular allegation of forged and fabricated plan has been raised. In most of the cases, the records were purportedly not found by the Vidhanagar municipal corporation. But in I can show at least 4 such instances for the division bench when this matter had happened. As well as particularly, I wish to refer to an order passed by the division bench matter wherein a similar allegation was raised against the party with regard to an issue of fraud. And the court had observed that the plan, the reconstructed plan from the plan we reconstructed from my records and also checking whether the particular building is in terms of the sanctioned itself. Same allegation was raised, but apart from this, there are several other orders which I can also please before my lord, where similar objection of forged plan has been taken by same respondent rather than same authority matter.
So what is the final outcome of it?
But generally, it has been directed, well, even in this particular order, it has been directed that the particular inspection be carried out, the records be reconstructed, because the main application is.
Then what happens after that, sir?
Thereafter, record is reconstructed with the authority, because there is a plan, there is a completion certificate. And this building has been standing since 2014 onward, manner. All the application, the FIR has been made after the.
So that's what I'm asking you. Travel a little further. What happened after that? After the submission of the plan, did they regularize it? In any of the matters where they have taken a
Under the
decision?
2006 Act, my lord, subject to correction, my lord, there is no such power of regularization. But my lord, only one thing, if your lordship notes in the order, they don't say that the.
Saying that if there are similar matters to this effect, what was the outcome? What is the
My lord,
final outcome?
Order I have handed over, page 4, my lord.
Of page 4 of
the order.
Give a copy to Mr. Nag.
Page 4. Whether or not the sanctioned building plan issued by the municipality is a genuine document, whether or not it is a forged document, first paragraph at page 4.
Yes.
Whether or not the sanctioned building plan issued by the municipality is a genuine document, whether or not it is a forged document, the question with me, this court is equipped to decide. However, we are of the opinion that the finding of the commissioner of BMC that the concerned plan is not genuine is a cryptic one, without being supported by sufficient reasons. Hence, we deem it appropriate to remand the matter back to the commissioner of BMC to consider the matter afresh and pass fresh written order in accordance with law. Accordingly, set aside the order of the commissioner. Commissioner ordered it so and so and remand the matter back
Commissioner of PMC being considered representation in accordance with law and come to a detailed finding as regard the genuineness or otherwise of the concerned building plan to have sanctioned by the municipality. The fresh decision will be taken after affording opportunity of hearing to the applicant and the private respondent. The exercise will be completed within a period of 6 weeks. From the date of communication of the order, will a fresh decision is taken here. From making any further construction. For the aforesaid purpose, let the applicant file a comprehensive application before the Commissioner of BDC annexing thereto authentic photocopies of all the documents, including the building plans that she wishes to rely upon. At the hearing before the BMC, a copy of the application shall be supplied to the private respondents. If I may come to the last portion of that page, we make it clear that we have not gone to the merits. Commissioner shall according to law, we clarify that Commissioner again in the event that the Commissioner is again of the opinion that the building plan is question is not genuine document, he will indicate in the order with sufficient clarity as to why he has the order of the was set aside. The exercise which was directed to be carried out for the purpose of ascertaining that exercise has not been carried out to order for the even if the facts of that particular case are not the particular related state, not when the building was raised. 10 years have passed since the building has been raised, and there are documents to that effect.
But here the commissioner has already passed an order.
Even in that case, my lord, the commissioner has passed an order which was set aside.
No. My lord, in that case, my lord, we had not come down to a finding that there is a forgery and we had not filed an FIR.
You can't come down to that finding.
My lord, forgery as in we are alleging forgery because our records, the records we have succeeded, does not match.
That is only because of the record, because you are not able to find the record.
My lord,
but that will not
my lord, I will indicate, my lord. My lord, we have a register which gives us the plan number and the completion certificate number. Against the plan number and completion certificate number, the person concerned for whom it is issued and the address is mentioned. So by that register, we can see that what are the plan numbers the erstwhile municipality had issued against which person and which address per se, the premises per se. So our records does not show that any plan of that number or any completion certificate of that number was issued in this particular case. That's why we had gone ahead and filed a FIR against Mr. Das's clients, my lord, who is representing the promoter, because it is not his clients, my lord. His clients are the purchasers, later purchasers.
And have you carried out the inspection of the property?
My lord,
to ascertain if the construction is in accordance with the rule?
No,
you have not.
Because, my lord, as we do not have any power to regularize, we did not go in that aspect.
As I indicated, several cases, my lord will see that the particular with regard to
inspection, rules inspection.
Subsequently,
But,
there the plans are received, and this is the stand taken which puts persons who have already obtained documents into such a place. Because had it been not been for this particular reason, my lord, the records or the whereabout of the records is not known.
But may I make one submission, Mallet? That kindly takes up page 317 once.
317.
317. Which order they chomkawe.
317.
Yes, Mallet. Mallet, this is the writ petition which has been filed by my learned senior friend's client. This is the writ petition which was filed by my learned senior friend's client, Mallet. In this writ petition, Mallet, where the motion was set to force, Mallet, and the Bidhannagar Corporation was directed. Now, Mallet, 318, that is the internal page 2, while disposing of the writ, Mallet, the coordinate bench directed certain things, Mallet. My lord, may I place, my lord, the fourth paragraph. Accordingly, the writ petition is disposed of with a direction upon the competent authority of the Bidhannagar Municipal Corporation to act and proceed in accordance with law by adhering to the following procedure. An inspection shall be conducted. Such inspection shall be held in the presence of the petitioner and the respondent number 8 and 9 within 3 weeks. Advance notice of the inspection shall be served upon the petitioner and the respondents and all other interested parties. But this was never done.
No.
It is an admitted position. This was never done.
It's done.
May I complete, my lord? Mr. Nag will continue, my lord. This was never done with greatest of respect, my lord. If the parties are not available to accept notice, the authority shall affix the notice of hearing and inspection at conspicuous place in their respective premises. Now, Mr. Nag will be at a better position to apprise, my lord, whether they have done that or not. Secondly, my lord, in case it is found on preliminary inspection that there may be reasons to believe that the construction was irregular and was continuing, the authorities may take interim measures by stopping such construction. C. The report of such inspection shall be prepared along with the sketch map. Admittedly, my lord, that is also missing, indicating the extent and nature of unauthorized construction, if any. Such report shall be handed over to the parties. My lord, no report has been handed over to us. A hearing shall be given to the petitioner and the respondent number 8 and 9. The parties must also be allowed to furnish their written objection version to the said report and adduce oral and documentary evidence in support of their contentions before the competent authority. All points raised by either party will be decided. A reasoned order shall be passed and communicated to the parties on the basis of what transpires at the hearing, and during inspection, the proceedings shall be reached to its logical conclusion in terms of the statute. The court has not gone into the merits of the claims and counterclaims, and the issues involved shall be decided independently. But I am an interested party by virtue of the deed of conveyance executed in favor of me. Today I am in position.
How was the deed executed?
Yes.
How was the deed executed? Yeah, lot has traveled.
That
But it kindly takes up my deed.
But the inspection has happened. We have served them the
No,
report.
no notice was ever served.
But they participated in the inspection.
I never participated.
But no notice was given.
I never participated in the inspection, my lord.
We have not participated.
Mr. Nag, any of the matters where any decision has been conclusively taken?
I'm sorry.
Any conclusive decision taken in any of the matters?
With regard to demolition, this kind of matters.
With regard to this kind of case?
Yes.
Because there's not only one case. There are a lot of cases like this.
We can come back where.
Please come
My
back.
lord, till today.
I'll be very candid. I'll be very candid to the effect that, sometimes we get lost in legal complications.
Even I would like to assess my.
But I think it is more to do with the fact that if somebody has already constructed, it has already been done. And after an inspection, we don't find any. I understand your predicament and your restraints which you have. But together we can, I think, cross that hurdle.
I just subject to what Milord says, Milord. We had gone ahead for the inspection. In the inspection, we admittedly did not make any measurements to see that whether the present building is in terms with the building plan.
We can do that again. That exercise can always be done. Frank, I mean, just have a slightly more open mind.
No, Milord, I am, but only difficulty is I don't have the statute to support.
I totally understand. But we can tide it over with something. You strengthen my hand, just see if there are any orders which have been passed to this effect. Because this has been going on for quite some time. When did the merger take place?
In 2015. June 2015.
And you tell me how many cases like this has been filed?
But as
Milord, we have gone ahead and demolished nearly maximum of the buildings which has appeared like this. Subject to correction, Milord.
You just find out. If you have demolished and this is the stand and you are demolishing it, then we'll see that. But on the face of it,
if there is no judicial order restraining us, our stand is to demolish. Because we have no other option, Milord. We
came from 7 judgments of division bench, and more than that, over the single benches where a stand has been taken to reconstruct the record.
My lord, if permitted, I shall.
No, not
judge it on
reconstruct
next
the record.
petition. If my lord so pleases.
By the
those are
question
division-
I asked myself, my lord, unless they cancel or withdraw the sanction plan, which is
Why
still
will they
valid.
do that? Their stand is, this is not my
Forged. This
sanction
is
plan.
forged.
This
So
forged.
investigation,
So
nothing.
they can't, investigation is already going on. They've got the FIR lodged. Why will they cancel it? If it is not theirs, they will not cancel it.
But
That
only,
will not help you.
but only one humble submission, my lord. I was protected by an interim order in this matter, which is continuing, my lord. Kindly, my lord, extend it for a limited period, my lord, so that we
Where
can.
is that order?
My lord, the initial order, my lord. Initial order time.
So you have filed your affidavit in opposition.
My lord.
My lord, my reply is also ready, my lord.
Your
My
reply.
affidavit in opposition has
reply.
already been filed in the department, my lord, because it was as per the directions of the Honorable Division Bench.
Rep-
Lord, I shall provide the date of the filing to my lord's officer, my lord.
Just
If
do
it
that
can be.
because I don't see
Right.
that here.
My lord,
Lord, it has to
yes, my
be
lord.
called for from the
Copy
department.
page. 2024 sir. Okay, নিয়ে নিলেন কেন order?
You have a copy, Mr. Nag.
Lord, the evidence in opposition? Yes, my lord. A spare copy have.
You have filed your reply to that?
My lord, I've just submitted, my lord. I've also served them. My lord, initially the interim order was passed on 10th of July, my lord.
Lord, I shall provide a copy within within the course of the day.
Just give that. So the pleadings are complete. Then we can have it for hearing.
Yes.
On the hearing.
Petition pleadings are not complete.
Doesn't matter.
The records from the first petition comprises of most of the documents. Kindly it can be.
Just take down. Mr. Nag submits that. And
My lord.
Because I am the affected party.
you are nobody.
I am the owner of the land.
Very good.
Because in my land, the illegal construction was banned. I made the complaint and come before this court.
File a civil suit, get a declaration.
Application for addition of party was not allowed, so
Nothing.
I am prepared to file them in opposition.
You go, no, not at all. File a civil suit. Take down. Mr. Nag submits that the affidavit in opposition has been filed with the registry. The same is not on record. The registry is directed to bring the affidavit in opposition on record. Full stop. Filing number, give the filing number.
Filing number to
Lord, I'm just providing the filing. Lord, on 27th January 2025, I had filed it with the registry.
Filing number.
Lord, there is no filing number.
There's no filing number. You don't
There
give the
is a
filing.
reflection in the status, case status, my lord, but there is no separate filing number now.
Filing 8 চাইছি
The entry number.
Filing number is there. There's no filing number here.
The councillor with the
এস নাম্বারটা সিরিয়াল নাম্বারটা এই যে এই নাম্বার
Look, that is the entry number. That is much older. We filed it with the
Or
department.
did you hand over a copy, Mr.?
Lord, I shall. Within the course of the day, I shall hand over.
Reply to the same has been filed by the petitioner and is taken on record. Let this matter be listed for, we'll keep it for hearing.
yes one yes
In the meantime, you get all the orders. Mr. Nag, you also.
Lord,
Let this matter be listed for hearing after 1 week.
Malad she keeps it in May Malad
Sorry?
May in the month of May Malad
When is your wedding?
22nd
April. Let this matter be listed for hearing on.
Unless he invites everybody, this
Yeah,
leverage must not begin.
absolutely. Why should we give you that liberty? You invite everybody here. Then only, and especially Mr. Nag is going to make that concession for you.
Well, Mr. Nag is already not married. Well, that's the difficulty.
Go what?
What is the difficulty? There is
People who are not.
But I was waiting. Well, first I will go to his wedding, well, but scenario changed. Well.
You are forcing people to get married just because you are getting married. This condition is, sorry, rejected.
Very.
So when do you want?
Well, any day in the month of May, well.
8th of May?
Yes, well.
8th of May? Oh, it's original side. 7th of May?
7th of May, well.
7th of May. We'll have it on 7th.
Well, my interim protection, well.
But
Lord, my
please, help.
interim protection is
Interim order granted by interim protection shall stand. Interim protection, interim order granted earlier shall continue for a period of till May 15th
15th.
or any further, whichever is earlier.
My mother already party left.
You make, go to the civil court.
From my mother.
Troublemaker. We will see that. We'll see and reject it next time.
Grateful.
at this hour. My lord, if my lord kindly, this is regards to an illegal allotment of shop rooms, my lord, in Asansol. Now, my lord, what has happened after passing of this order, if my lord kindly peruses this once.
Whose order is this?
My lord, this is the previous coordinate bench's order, my lord, Justice
Tomorrow,
Chandra's order.
mention it tomorrow.
My lord, the difficulty is, my lord, they have, this is against the illegal allotment of shop rooms, my lord. They have already published the names of the parties who are going to be allotted the shop rooms, your lordship.
Tomorrow, mention it tomorrow.
Tomorrow is the meeting, your lordship. That's why I was praying for urgent hearing of the matter, my lord.
Not at this time.
Great.
Number 18.
Item number 18, my lord, I pick to appear on behalf of the writ petitioner.
And I am for the respondent private.
My lord, I'm appearing for the respondent number 5 and 6, my lord.
Private respondent number 1 to 4, my lord. I am.
Lordship,
I'm
we have
for
what
5.
happened. The writ petition is writ petition and his family member, along with his family member, reside at the address in the cost title. He is not having the water facility for more than a year. So accordingly, he prays for a water connection to the municipal authority. After sanctioning that municipal authority, they raised a bill. We made the payment for that a year long back. We made the yet no connection has been made. The corporation.
My lord, I am for the private
My lord.
respondent. They are not the.
My lord, I am for the private
Owner and
respondent, my lord, for 5 and 6, my lord. My lord,
We made a
my lord, kindly turn to page number 9, my lord.
You're for?
Kolkata
KMC.
Municipal Corporation, my
What is the status?
My lord, I am led by Mrs. Seema Chakraborty.
Where is she?
As she is not available today, my lord, kindly make it not
Not
this week,
today.
my lord.
Why not this week?
My lord, she is out of station
When is she coming back?
on 9, my lord.
Not this week.
My lord, could it be on Friday or on 22nd?
Not this week, she's saying.
I will. I have some personal difficulty next week, Your Lordship. I have,
So when do
it's a prayer for
when do
consideration
you
of my
want it?
application.
Next to next week?
22nd, my lord.
22nd.
22nd. Grateful.
Item number 19.
I am for the respondent number 12 and 13, lordship. Third floor, fourth floor, fifth floor, illegal. Earlier it filed, corporation contended and accepted that they are illegal construction. Order was passed to demolish the entire structure. Page 29, lordship, of my writ petition. This order is dated 16th January 2024. The report mentions about 3 additional floors being constructed beyond the sanctioned 3-story building plan, encroaching the mandatory side open spaces. The report further mentions that the apartment has already initiated demolition proceeding and the illegal structure will be demolished shortly. It's more than a year, lordship, and the building is still standing tall.
Yes, Mr. Mukherjee.
Lord, as I have been instructed, portion of it has been demolished, already demolished.
Why only a
Is
portion?
the time? The Lordship gives me a time.
A year and a half has already gone.
Yes, my lord. My lord, my tongue is locked behind my teeth. My tongue is locked behind my teeth.
Let the proceed and kindly fix another date with the photograph if they can show.
Of course.
Good for you. Take down.
Grateful.
Lord, can keep this on record.
Learned counsel for the respondent, Calcutta Municipal Corporation, Mr. Mukherjee at the outset submits that though there has been a considerable delay in compliance of the order dated 16/1/2024, full stop. He states that demolition action as per he states that partial demolition action has already taken place on 6/3/2024, full stop. he further assures this court that necessary compliance in terms of order dated 16/1/2024 shall be made within a period of
Alert, directs, subject to what falls from your lordship, directs my executive engineer. Alert, directs the executive engineer, alert, gives 15 days time, and also directs that he should produce of Boro 7, produce the photographs to show
Respondent
that
number
the-
3.
that the demolition has actually, and to what extent it has taken place. Might be it not be completed by 15 days, but at least I can place before my lord that this much has been done and this is remaining.
Respondent number
क्या
3.
लिखा है last line no ऐसे कर लो learned the Calcutta Municipal Corporation the respondent
Respondent number 3, lordship.
Executive Engineer Building Department Calcutta Municipal Corporation Borough 7 shall file an affidavit
Along with photo.
of compliance along with pictures to show what action has been taken and whether necessary compliance has been made of the order dated 16/1/2024 in WPA number 23449 of 2023.
Great.
Full stop. The same shall be done within a period of
15, at least your lordship fix 15 days.
3
If
weeks.
something is
3 weeks.
remaining, I can always pray for
3
some
weeks.
time.
3 weeks.
Within a period of 3 weeks, let this matter be listed after 3 weeks.
Grateful, lordship. Much obliged.
Mr. Mukherjee, this is
Alert,
not
police,
here.
police assess.
This is here. Just take now.
Police. Respondent number 4.
Respondent number 4 shall cooperate and provide all necessary help to the respondent corporation in carrying out their statutory duties.
Much obliged. Much grateful.
Number 20 and 21.
Lord, 20 and 21. In 21, I appear for the petitioner. Lord, item 20 has been filed, Lord, seeking implementation of an order of demolition. And 21, I have challenged the same order of demolition. So, Lord, my Lord, if my Lord takes up item 21,
First 20 or 21?
WP 20449, because if I succeed, then his writ petition will automatically fail.
So you have challenged the demolition
Order
order.
On 2 counts. Lord, my point of challenge is, Lord, firstly, violation of natural justice, and secondly, the person who passed the order of demolition is not authorized to do so. Lord, to buttress on my point, my Lord will kindly come to straightway to the order of demolition.
Item 21 there, no?
Item 21 20449.
ये 21 है. Yes.
My Lord has 20449.
Yes.
My Lord, kindly come to page 21. 20, the order of demolition starts. My Lord, I am not going into the merit of that, not for the present. My Lord, kindly see who has passed the order. My Lord, the superintending engineer, Asansol Municipal Corporation. My Lord has kindly got that.
These are all delegated powers which are
Not
given to
not at all. Not at all. I shall satisfy your lordship, my lord. Justice Chondom, lord, after hearing us, was prima facie satisfied and my lord protected the right of the petitioner that there is no delegation. I'll try to satisfy your lordship, my lord. Kindly, my lord always allows me, my lord, kindly take the statute. Copy though. এই বইটা আছে 206. My lord, kindly take this. Marking. Corporation Act 2000 বইও আমি করতেছি আমার বই কোথায় এসব পিছনে নিয়ে দাঁড়িয়ে আছো কি দে বাবা
Calcutta.
No, this is not West Bengal Municipal Corporation Act. Because this is coming out of an order, not this book. I'm referring to this 2006. My lord may take this one. My lord take this one. Yes, I believe that one, the third one from the top. I think that's the book.
Yes.
Not kindly take not section 266. I believe it will be in page 149. Malaskali got that? Order of demolition of building or stoppage of erection of building in certain cases and appeal. Where the erection of any building or the execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to section 263. Now 263 is a provision which enables to sanction a plan, or in contravention of the provisions of this act or the rules or the regulations made thereunder, the commissioner may, in addition to any other action that may be taken under this act, make an order directing that such erection or work shall be demolished by the person at whose instance the erection or the work has commenced or is being carried on or has been completed within such period, not being less than 5 days and more than 15 days from the date on which the copy of the order of demolition with a brief statement of reasons thereof has been delivered to such person as we prescribe. So, my lord, subsection 1 talks about the power of the commissioner. Then there are 3 provisos. Kindly allow me to place the proviso. Proviso 1, provided that no order of demolition shall be made unless such person has been given by means of a notice served in such manner as the commissioner may think fit a reasonable opportunity of showing cause why such order shall not be made. So it talks about show cause. Then 2, provided further that where the erection or execution has not been completed, the commissioner may, by the same order or by a separate order, whether made at the time of the issue of the notice under the first proviso or at the other time, direct such person to stop the erection or execution until the expiry of the period within which the appeal against the order of demolition, if made, may be preferred. This talks about stop order. Then kindly turn the page, kindly come to the third proviso. The third proviso reads as follows: provided that the commissioner by order delegate his powers and functions under the first and second proviso. First proviso is the power to show cause, second is to stop work. To proviso of the subsection to the special officers appointed by the commissioner with the approval of the state government on such terms and conditions as may be determined by the corporation, and the expenses for payment of such officers shall be borne by the municipal fund. So, Lord, section 266(1) talks about the power of the commissioner. There are 3 provisos which qualifies the section. First is that you cannot pass an order without a show cause. Second is you have a right to stop construction. And third is that the power under proviso 1 and proviso 2 you can delegate. So, my lord, the power under subsection 1, the power of demolition, has not been delegated. There is no power given to the commissioner to delegate this power. Now, this is a exhaustive section. This, Lord, if my lord allows me to.
Why did you prefer an appeal?
Lord, this is an order without jurisdiction. If it is an order, my lord, kindly recollect, Lord, Walpole Corporation, I can come before your lordship. Lord, if it is without jurisdiction. Lord, kindly, this is a very exhaustive provision 266. Subsection 2 talks about that the commissioner may make an order, notwithstanding there is a payment of tax. 3 talks about a provision of appeal. Now, this has been amended. Earlier, there was an appeal to the mayor. Now, this is, my lord, it talks about that any person aggrieved by the order of the commissioner within 30 days from the date of the order, prefer an appeal to the municipal tribunal. Although there is no tribunal, then where an appeal is preferred against an order made under the municipal building tribunal may stay the enforcement of the order, so and so. Then 5, save as provided in this section, no court shall entertain any suit, application or other proceeding on injunction. Then 6, every order made by the municipal building tribunal in appeal, subject to the order made by the municipal commissioner under subsection 1 shall be final and conclusive. Where no appeal has been preferred against an order made by the commissioner under subsection 1, where an order under subsection has been confirmed in appeal without any modification, the person against whom the order has been made shall comply with the order within a period specified so and so. So, my first point is this is without jurisdiction. My lord, you kindly take one more provision of this act. I will be failing in my duty if I don't show that. Kindly, my lord, take section 47. kindly take section 47, there is a general power of delegation. Now, my submission is that when there is a special power and a general power, special power will always prevail over the general power. Now, kindly take section 40. My lord, is that 47, my lord? Delegation of power and functions. The Board of Councillors may by resolution delegate, subject to such conditions as may be specified in this in the resolution, any of its powers and functions to the Mayor in Council. 2. The Mayor in Council may by order delegate, subject to such conditions as may be specified in the order, any of his power and functions to the Mayor or the Commissioner. 3. Subject to 3 para should apply, subject to standing orders as may be made by the Mayor in Council in this behalf. Then kindly read B. The Commissioner may by order delegate, subject to such conditions as may be specified in the order, any of the powers and functions to any of the officers or employee of the corporation. Lord, it was submitted before Justice Chondo by the corporation that under 47(3)(b), the commissioner can very well delegate the power of demolition. But if my lord considers section 266 provides third proviso, which qualifies 266(1), it says that the power of demolition which contains in that particular section only with regard to issuance of show cause and stop work, the power has been allowed to be delegated. So, my lord, when there is a special provision and there is a general provision, special provision would always prevail. That your lordship has held, my lord, in 61 Supreme Court, my lord, AIS 61 Supreme Court 1170. Copy them. 61 Supreme Court 1170. Lord, kindly consider paragraph 9 and 10. Lord, I say that 266, it's a special provision, only deals with the demolition. And the statute in its wisdom has very clearly says that which portion of that provision could be delegated, which portion could not be. What is not given, my lord, that cannot be executed. That, my lord, your lordship has laid down the law, my lord, which cannot be done directly, cannot be done indirectly. Kindly take paragraph 9 and 10 of this judgment, my lord.
Yes.
There will be a complete harmony. My lord, kindly got that paragraph 9. There will be a complete harmony. However, if we hold instead that clause 5A will apply in all other cases of proposed dismissal or discharge except where an inquiry is pending within the meaning of clause 23. We reach the same result by applying another well-known rule of construction that general provisions yield to special provision. The learned Attorney General seems to suggest that while this rule of construction is applicable to resolve the conflict between the general provision in one act and the special provision in another act, the rule cannot apply in resolving a conflict between the general and special provision of the same legislature. That was the submission of the AG. Then kindly see what the court says. The suggestion does not find support in either principle or authority. The rule that general provisions should yield to specific provisions is not an arbitrary principle made by lawyers and judges, but springs from the common understanding of men and women that when the same person gives two directions, one covering a large number of matters in general and another to only some of his intention, is that these latter direction should prevail as regards these, while as regards all the rest of the earlier directions should have effect. The rule is that whenever there is a particular enactment and a general enactment in the same statute and the latter taken in its most comprehensive sense would overrule the former, the particular enactment must be operative and the general enactment must be taken to affect only the other parts of the statute to which it may properly apply. But kindly take paragraph 10. Applying the rule of the construction that in case of conflict between the specific provision and the general provision, the specific provision prevail over the general provision, and the general provision applies only to such cases which are not covered by the special provision, we must hold that clause 5A has no application in the case. Lord, the commissioner may have thousands of work in a corporation. Lord, the commissioner under section 47(3)(b) has the power to delegate other general work. But Lord, kindly considers that perhaps the idea behind Lord enacting 166 is, Lord, this is the provision which will affect a person to the most of the extent. because this is a provision whereby the commissioner will direct demolition of somebody's house. So for that, the statute must have thought that it is the commissioner who himself should do it, not any of his subordinate. That is why, my lord, the third proviso specially clarifies that only proviso 1, that is show cause, and proviso 2, that, my lord, the power of issuing stop work could be delegated. And, my lord, our honorable court, my lord, in 40 CWN has laid down this law, my lord, Justice Ashutosh Mukherjee, long back, my lord, that something which is not provided in the statute, a statutory authority, my lord, cannot do that. Moninuddin Bapari, my lord, I'll place that judgment before your lordship. My lord, this 61 Supreme Court was followed in 2019. 2019 5 SCG 480.
Who appears for the corporation?
Lord, I have two more points. Lord.
Want a reply or what do you want?
I'm so sorry.
Yes, you appear for the corporation. What is your stand?
And similar section 47. Section
In it.
47 because C Millard is otherwise very clear. It says in lordship once again says Millard any officer of the corporation other than the the commissioner may delegate subject to condition that may be specified in the order any of his powers or function. It says any of his powers or function. Any. Now Millard lordship has to decide whether 266 will override section 47. Any of his powers and functions.
File your reply, show the delegation. We'll see.
Yeah, there is a general delegation, Millard, all. Millard, the superintendent engineer has been delegated, Millard, in view of 47P, Millard.
I have a very short submission on this point. It has given reply, my lord, but the locus standi of this person, because the order has been given against the petitioner, against some other persons, she is claiming he is the owner of the land.
Yes.
He is the only owner of the land, order has been given some other persons. What is the locus standi to challenge the veracity and legality of this person's delegation?
I am the owner of the building which is sought to be demolished. I'm the mother. I have annexed documents. But I'm so grateful. I'll show that. I'll show that.
Coordinate bench, my lord. His lordship only directed.
Kindly have a look at page 17.
Already giving a chance of hearing. Nothing more, nothing less, my
You
lord.
order this, देखो.
My non-even appear in that matter, my lord. Then he was taken because top up notice has been given.
এই মক্কেলের নয় তো এই মক্কেলের নয় তো এই ম্যাটারের নয় not in this matter.
But identical situation that lady came and said, I'm the owner of the land. I have not given any notice. And only the she should give
করে দাঁড়িয়ে আছিস
locus standi to challenge the same.
That is nothing has been annexed, Millard, showing that.
Yes, page 17. I have annexed that. Page 17, my lord may have a look at it. My name is recorded in the ROR with regard to the same property. I'm the owner. I have not been hard.
Order is given to some other persons.
So you will not
saying I have no connection with the another construction. She's saying they are enemy. My son says made. I have no knowledge. Now how could this challenge the order in I fail to understand. I put this question to myself.
Yes. Ultimately জিতিয়ে যেত না সেটা সেট করে yes
At this order,
they are also the court citizen.
Except my final order being passed. At this statement, we have no locus standi to challenge the order. That who has passed the order?
Yes, what are you showing?
My lord, yes, page 17 of the petition guy takes up.
What is your name?
Ruxana Zakaria. তাই তো Ruxana Zakaria.
You claim to be the owner.
Yes, and the order has been passed against my sons. Lord, my case is that is the case that is made out in the writ petition.
Yes.
That, Lord, that it's the entire area is known by my Lord great grandfather-in-law. But he was the a big businessman there. Now there is an outhouse. Main house, there is an outhouse within the same complex. Now in Amphan, that outhouse not got damaged. Lord, after the death of my husband, there was a dispute between my Lord daughter-in-law, son, and me. So I moved out to the outhouse. I repaired that outhouse. I started staying there. Lord, I am the owner, recorded owner. The municipality did not give me a notice, gave only notice to my sons who did not oppose, who did not challenge that order. They would be very happy if it is demolished. Now my learned friend takes a point that not the persons against whom the order is passed has not come. My first point is that it's with the, there is no, it's in violation of natural justice because I have not been heard. That's my first point. Kindly take page 17 once.
I can't read Bangla, translate it.
I'm so sorry, Lord. I apologize, Lord. I apologize.
Translate it.
Lord, কবে রাখছেন just translate করে দেওয়া হোক. But I'm so sorry. I'll do that and come back. I'm so sorry, Lord. Lord, only one thing, Lord.
Nothing.
My Lord is keeping it not on.
When do you want? When are you going to get the translation done? When will you get the translation done?
Lord, keeps it, Lord. কবে রাখবি বল? 2-3 days we might take. It might take, Lord.
You tell me when do you want? Next Monday?
Next Monday.
Next Monday.
Oh, 19th. Keeps it on 19th.
19th.
Sorry.
Saturday,
21st.
Saturday.
21st. No.
Keep it on 23rd.
Lord, the interim order is there till 25th of April.
23rd.
Lord, my Lord will extend the interim order in
No,
case it is not
23rd.
taken.
I'll dismiss it. You come on 23rd. I'll see.
Lord, my Lord will not ask them to file any opposition or any reply to this.
I'll see if I want to entertain this or not. 23rd.
As well as well as. Lord, I am only placing on a pure question of law. That
Not only pure question. You don't have a right.
My Lord,
If you're not the recorded owner,
I am the recorded owner. My name is there.
we'll see that.
That I have annexed. I'll later translated copy that I have annexed. It's not their case that my sons are the recorded owner.
It has been issued to whom?
To my sons. That is the case of the demolition order. That is recorded. No, that is recorded in the. That is recorded in the demolition order. That is recorded in the demolition order. That the demolition order.
Challenge it before the tribunal, sir. Principle of natural justice.
There is no tribunal.
There is a tribunal.
There is no tribunal. No tribunal has been constituted under the Act. Yes, there is no tribunal. Now, there is only one tribunal in the entire state, that is for Kolkata Corporation. No tribunal has been constituted.
There should also be delegation.
But then I have to come to your Lordship's court only. But the question is whether this gentleman could have passed the order or not. If he is not authorized, if there is a special power and the general power, which one should prevail? Because this issue came up before Justice Tandon, his Lordship sitting singly with to Kolkata Corporation. Earlier, the Kolkata Corporation, you should delegate not the power to a special officer without he being an employee of the corporation. Lord, I am carrying that judgment as I place it on that day, 2015 5 CHN 309. Justice Tandon set aside the entire process in several matters. Then the corporation changed their rule and then authorized that there was a proper delegation. So this question of law was entertained by Justice Tandon, although on a different ground. But here, my main point of challenge is that whether the superintending engineer could pass an order of demolition or not.
We'll see that.
If he could not, then I have a case. If he can or if he could, then I have to take your Lordship to the merit of the matter. On the merit of the matter, violation of natural justice, and I'll rely on a judgment of Justice Jyotirmoy Bhattacharya, that there is no sketch map, no precis has been given. These are my 3 points of challenge.
We'll see.
These are my 3 points of challenge. But it's not that always the corporation will issue notice to someone who is not owner. It was their duty. I am the recorded owner.
Subject to correction, my lord, 266 says.
And the question is,
Corporation will serve not surely.
and my lord, my learned friend wants to get it demolished. My lord will kindly inquire from him whether his building has a plan or not.
Yes,
He wants to get it demolished. Let him also produce that.
You are in item.
Yes, he wants to get my building demolished. Let him bring that. Lord, it is the vengeance. It is the vengeance which is not coming through the writ petitions.
In spite of my lord's proper notice, they have constructed 3,000 square feet building, and thereafter, my lord, the corporation found to complain before the commissioner of police. Police came and only they stopped construction.
It is not the corporation.
And there is no other construction, my lord, 7 next to the another structure. He is saying that I have a dilapidated condition house, I am the owner of the land. Corporation acts as my lord, only the person responsible. Maybe the owner.
No, I think he is incorrect. 266. Lord, kindly take 266 explanation note. It says that the owner has to be given.
No,
I think he's not correct.
Personal responsible.
Yes. Very well, we'll come back on 23rd.
Question number 22.
I have the instruction to appear on the petitioner. But I'm just praying your lordship. But kindly consider my report. I just pray for an accommodation on the ground of my legislature.
This is concerned, Lord, we have nothing to do.
Just praying for accommodation.
Why, what happened? What is the difficulty?
But I am ignorant by minutes. Just praying.
So far as the police concerned, police authorities concerned, Lord, we have filed our report because we have nothing to, Lord, act or play over this. Yes, municipality can answer.
Under the provision of 171, 180,
Not passing any order.
85 and 181, I have every right to encroach the public land for the purpose of ingress and egress of the
Not
road.
public land. Because I am appearing on behalf of railways.
Railways.
Railways claim that is their property, not the
No,
municipality.
issue is this, Milord, issue is this, Milord, now there is no railway plan. This is not the municipality property, but this is very emergent for the public safety to entry and exit. There is a only entry point. Only entry point. There is no exit point.
Who's the landowning agency?
Yes, Milord.
Who's the landowning agency?
Milord, landowning agency is the railway. This is the fact. This is a fact. I am not denying, but we are within.
So can you take action on railway land?
Yes, Milord.
Can you take action on railway land, sir?
I am not taking. I am suggesting to give with the joint consonance of the both the authorities with the railway and local authority. We are set up the road because of the safety and security. Milord can appoint a special officer.
Who do you appear for?
I am for railways because there is.
Railway is denying it.
Yes.
No, because there is
No.
license.
Because it's a lease pendant. No. Milord, issue is this. The matter is lease pendants. This is a very long pending matter. There is another matter over here to sit with there is a khatals over there. Milord, kindly see the report of the state government. Unusual encroachment of the lands of the illegal occupants are over there.
Does the land belong to you, sir? No.
It's a authority's land.
Just now you said railway.
Yes.
You are in talks with railway.
Yes.
Both of you have decided to clear it.
Yes.
Council for the railway says he is not aware.
No.
Yes.
Issue is
There is
this.
no proposal.
Proposal. Milord,
Show me the letter which you have written to railway.
I have not written.
Don't say no.
Because
No, it will not help you. No.
listen to me, Milord. Issue is this. The issue is pending since from the 2000.
So, sir, I don't care whether the issue is pending for 100 years.
We have
At least when you are making statements, back it up with letters.
Milord, we have.
Have you written to railways?
On instruction, I have said we have issued the letters to the authority, but right now which is not.
Where's your letter?
Not there. I have to file.
Don't make any statement without proper documentation. Railway is standing here. He's saying you have not made any. You have not communicated. There are no letters.
তুমি একটা রিপোর্ট ফাইল করো যে হ্যাঁ ঠিক আছে
That's okay. I will file the
Kar
letter.
de
No,
bhai,
this is the letter after this writ petition. I have received the letter from the railway authority.
And what does it say?
They have said the humble request to kindly provide plot numbers, particulars, and areas relevant documents, and in favor of eviction. There is no eviction, Milord. Milord, there is no eviction over the property and over the inhabitants.
So you can't touch the land.
No, Milord. This is not my land, Milord. This is.
So if it is not your land, stay away.
Yes. Milord, issue is something else, Milord. Kindly see the writ petition once. I am indicating the paragraph wise and page wise, Milord. This is the property belongs to the initially Victoria Jute Mill with the consonance of the railway authority to.
It doesn't matter who it initially belonged to. Today, who's in occupation? Railways.
Yes, it's admittedly railways property.
That's why they are sending and write a letter to them, indicate which is your land.
Milord,
Respond to the letter.
Milord, After going through the case petition, it is found that the petitioner have been the aggrieved notice eviction. Lord, there is no eviction notice at all. Lord, kindly see the notice here. It's only to sit and talk with some proposal. This is the page, Lord. Kindly come to page. Read petition, Lord. Kindly come to page 134 once. This is the Bengali letter. It has been written by the chairman. This is the aforesaid. I am just translating to English. This is Bengali language. I am translating to English to my lordship.
I understand Bengali language.
Yes,
Read
yes.
it.
উপরোক্ত বিষয়ে আলোচনার জন্য আপনাকে আগামী 5-3-2024 তারিখে এবং 6-3 মঙ্গলবার বুধবার বৈকাল 3:30 পৌর করণে নিম্ন স্বাক্ষরকারীর সাথে স্বাক্ষর করতে জানানো হয়েছে। All are the letters to sit and talk about the issue. What is the issue? This is the রাস্তা সংক্রান্ত বিষয়ে আলোচনা।
We'll have it. When do you want?
Mediation.
Next week?
If your lordship, if your lordship, if your Thursday, this is
No, Thursday can't be possible. We have original side matter.
Lord, your lordship, kindly will keep the report on record. Lord, we are fine.
Why are you filing the report right now? We'll see next date.
Could it be subject to lordship?
Because report will not assist your lordships, Lord, the land belongs to whom, and Lord, what is the nature of Lord, the case concerned, subject matter of case concerned. That is why police has no role to play over this. That is why, Lord, but we have been made party to these proceedings. That is why, Lord, we have filed this report. But subject to your lordship's kind consideration. Huh? Dara bhai.
21st of April, which is Monday.
21st. 21st. Report is kept on record. Report filed by the state is kept on record. Let this matter be. Give a copy of the report.
I'll circulate. দেবো জেরক্স করে ঠিক আছে
List on 21st.
List on 21st.
21st.
Now obliged to your lordship.
I have to sit in the division bench. So I'll rise, I'll sit after 5 minutes.
And I'm fortunate one to appear before your lordship's thinking.
The rest of the matters tomorrow. I have 2 DB matters.
My lord.
The other matters will take it up tomorrow.
Your Lordship, I appear on behalf of the municipality. My senior is at Lax. I request a short pass over.
We are not taking any matters, madam. You didn't hear.
Sorry, sir.
Only the division bench matters I'll take down.
Mention one matter, my lord.
No mentioning, madam. This is
My lord, assign matter, my lord. Assign matter.
a division bench, madam.
It is not regular division bench.
Division bench matter, principal bench, item number 1.
My lord, I appeared for the applicant, my lord. Yes. My lord, the petitioner. My lord, the petitioner is a tenant and the private respondents are the landlord. Correct. And my lord, since 1980, by virtue of a registered agreement, the petitioner tenant is running a business of sawmill, and he constructed 3 shop rooms over the plot of land of the landlord and paying the rent. And my lord, the landlord are disturbing on several occasions and moved to writ application, and protection was given by the learned single bench of this honorable court. And my lord, they have filed again thereafter, my lord, a civil suit for eviction of the tenant. And my lord, that suit is pending before the Diamond Harbour Court. And my lord, the injunction application was refused. After dismissal of the injunction application, order 39 rule 1 and 2, they have moved a writ application on a new plea that the building is has no sanction plan. Made a representation to the Pradhan, and the learned single bench dismissed the writ petition. Against that dismissal order, they have preferred an appeal, and the appeal appeal was allowed. This appeal, my lord, page 77. Yes. My lord, page 77 is the appeal. Yes. This order was passed by the Honorable Justice John Malabhachi and your Lordship Justice Kant, my lord. Yes. Page 77. My lord, the may I place paragraph 4, 78. Yes. It may not be out of place to note private testimony of 5 complaining that appellants and others were obstructing his running of the sawmill, had approached this court in WTA number so and so, and learned single judge directed the police authorities to see there was no obstruction in running the mill. Subsequent thereto, another writ petition being number so and so was filed by the private respondent, which was also disposed of, observing the dispute between the parties is civil in nature. Thereafter, a civil suit has been filed by the appellants against the private respondent, but no order of injunction has been passed in favor of the appellants. Relying on the aforesaid facts, honorable single judge was of the view the grievance of the appellants ought to be agitated in the pending civil proceeding and dismiss the writ petition. Honorable judge had failed to consider that the prayer in writ petition was for removal of unauthorized construction made by the private respondent number 5, and the representation had been made that effect before the Panchayat authorities, being annexed at page 29-30 of the state application, or is vested with the Panchayat to make recommendation to the sub-divisional officer for demolition of unauthorized construction. This issue cannot be addressed in the civil suit pending between the parties. While the suit is pending and both parties are contesting the suit, this is an eviction suit. My lord, next, in such view of the matter, we direct the respondent number 3, Pradhan, Radhakantapur Gram Panchayat, Gilarchot, PS Rajuri District, South 24, to consider the representation of the petitioner at page 29-30 of the stay application, and after giving opportunity of hearing to the parties to take a decision whether the construction is unauthorized. 1. My lord, this point has already been decided by the civil court. My lord, I have annexed the order of the civil court. My lord, this point was not placed at the time of hearing when your lordships were passed the order. My lord, page 67. Yes. Of my application. The court was conscious of the fact that there is a civil dispute.
Yes.
Considering the submission.
What is your ground for review?
Madam, this issue has already been decided by the
error apparent on the face of record. That the court erred in not taking note of this fact. But the court was very much conscious that a civil suit is pending. And despite noticing such fact, taking note of this fact, the court passed that order. So you are not in a position to re-agitate that issue again.
My lord, the point has already been decided
and now it attracts the principles of res judicata.
Huh?
Res judicata. This, my lord, I'm placing 4 or 5 lines.
Yes.
Considering the submission of the learned advocate of the plaintiffs.
Which
and
page you are reading, sir? Which page?
Page
Page
67.
67.
The order passed in the
Yes, sir. Yes.
order 39 rule 1 and 2.
Yes.
Considering the submission of the learned advocate of the plaintiffs and on perusal of the material available in the record, this court finds that defendant number 1 is the tenant under the predecessor of the plaintiffs in respect of procedural property. Plaintiffs allege that they gave permission to the defendant number 1 in respect of procedural property. But now defendant number 1 is trying to make construction of procedural of land. Plaintiffs had revoked their permissive possession in respect of procedural of land. Now plaintiffs prays for order of injunction in respect of procedural of land, so that defendant number 1 cannot make any construction work over procedural of land.
So this was rejected, sir.
New construction or, my lord, the changing the nature and character, that point has already been decided by the civil court. Again, after 45 years, construction was made in the year 1980. After 45 years, they moved the writ application before this honorable court, and single bench dismissed the writ petition. Against that order, my lord, they preferred an appeal, and this is the order of the appeal.
We are only concerned with the unauthorized construction. There is
Yes,
no other
yes.
direction.
Yes,
We are not
come to-
getting into it.
On to page, last line of page 7, para 7 of the order.
Of the impugn
The,
order.
Yes, the last line, the issue cannot be addressed in the civil suit pending between the parties. That is the very important line of the finding of my lord, the division bench, my lord and Justice Jaimal Lawakji. Now the honorable judge of the apex court.
Now, what my brother judge is showing is para 7, where the court is
The last
conscious
line,
and
the
it
only
is-
last line. The issue
Okay.
cannot be addressed in the civil suit pending between the parties.
Yes.
And this is only the, my lord, in respect of the whether the construction is unauthorized or not, whether sanction plan is.
Anything else, sir?
My lord, this point has already been placed by the plaintiff landlord, and this has already been decided by the civil court.
And my lord, this is my lord,
Take down.
my lord, the review is being pressed at this moment. Is my lord, because the hearing has been conducted. It has
The
been
review
found by us that
petition.
there is some illegality.
The review petition has been preferred, seeking review of the order dated 4/10/2024. Yes, sir. Honorable Supreme Court. The scope of the review is very limited. Yes, sir.
Civil suit having been dismissed in respect of same cause of action, held writ petition not maintainable. Paragraph 4 and 9. Paragraph 4 and 9. My lord, I am reading at the
Yes.
middle, my lord, I am not wasting the time of this on court. My lord, at the middle, my lord, point D, right hand side, that respondent had filed a suit in the court of subordinate judge Jaipur against the appellants claiming compensation for the death of the deceased being money suit number so and so. The said suit was dismissed by the subordinate judge Jaipur Bhai, order dated so and so. Thereafter, after a delay of 10 years in the year of 1994, the present writ petition was filed in the High Court. The High Court, ignoring the fact that the suit filed on the same cause of action had already
Same
been
cause of
dismissed
action.
and awarded compensation to the respondent. According to the appellants, the death occurred not because of their fault, but due to the act of God. And my lord, page paragraph 9 of the paragraph 9 also. In the present case, the appellants had disputed the negligence attributed to it, and no finding has been recorded by the High Court that Gridco was in any way negligent in the performance of its duty. The present case is squarely covered by the decision of this court in chairman case so and so. The High Court has also awarding compensation in civil number so and so. The subsequent suit or writ petition would not be maintainable in view of the dismissal of the suit. Well, another decision of this court, this is reported in 1996, volume 3 SCC, page 11. Well, paragraph, I'm placing paragraph 8.
96 3 SCC. Page
11. Paragraph pressing paragraph 11. We are of the view that the High Court not only fell into patent error but also exceeded its jurisdiction under Article 226 of the Constitution of India. Though the jurisdiction of the High Court under Article 226 of the Constitution is not confined to issuing the prerogative writs, there is a consensus of opinion that the High Court will not permit this extraordinary jurisdiction to be converted into a civil court under the ordinary law. When a suit is pending between the two parties, the interim and miscellaneous orders passed by the trial court, against which the remedy of appeal or revision is available, cannot be challenged by way of petition under Article 226 of the Constitution of India. Where the civil court has the jurisdiction to try a suit, the High Court cannot convert itself into an appellate or revision court and interfere with the interim or miscellaneous orders of the civil court. The writ jurisdiction is meant for doing justice between the parties where it cannot be done in any other form. My lord, against the order of Order 39, Rule 1 and 2, my lord, Order 43, Rule 1 is remedy is available. Order 43, Rule 1.
Appeal against order.
Lordship. Against the Order 39, Rule 1 and 2.
So the injunction was absolutely on a separate point.
Page 65 is the prayer, madam. Prayer in the suit, page 65.
Consider both this judgment was pronounced on the issue that the same issue before the civil court as well as before the writ petition filed before the honorable court, and hence this judgment was passed. But here issue is not the same.
Yes, my lord, same, because I am placing the application of the Order 39, Rule 1 and 2.
Oh, whether the building is unauthorized or not, whether the subject matter of the civil suit.
No, sir, my lord, the prayer, page 65 is the page 65 is the prayer. My lord, your lordship kindly see the plate. Page 65 is the prayer. তফসিল বর্ণিত ভূমিতে আর্জির প্রকাশ মতো বাদীর উত্তম সত্য থাকা সাব্যস্তে নালিশি তফসিল ভূমির বাদীর বিবাদীগণকে প্রদত্ত বিভোগ or these are totally another eviction. This is not relating to the unauthorized construction.
Suit for eviction, he was making a construction, my lord, after my lord
This is not.
That's why my lord, the injunction application was prepared.
But that is not for the unauthorized construction. And unauthorized construction, my lord, that civil court will also not deal. It is the specific power given to the Panchayat Act under section 23. Whether sanction has been given, whether the building has been constructed with the sanctioned building plan, this is to be considered by the Pradhan first and thereafter the SDO. What has been done, my lord, and the division bench has passed the very specific order in paragraph 7.
Page 104. This is the application. I have annexed the application.
I've heard you, sir.
1 and 2.
I've heard you, sir. It's a different cause of action. Take down.
My lord, no, my lord, kindly see. Page 104. This is the prayer of Order 39, Rule 1 and 2. এমতে প্রার্থনা আদালত দয়া প্রকাশে উপরোক্ত কারণে বর্তমান মোকদ্দমা চলাকালে মূল 1 নম্বর বিবাদী যাহাতে বাদীপক্ষকে নালিশি ও গ তফসিল বর্ণিত ভূমি হইতে জোরপূর্বক বেদখল করিতে বা নালিশি খ গ তফসিল বর্ণিত ভূমিতে জোরপূর্বক দখল করিতে না পারে বা নালিশি খ গ তফসিল বর্ণিত ভূমির ক্যারেক্টার চেঞ্জ করিতে না পারে তন্মর্মে মূল বিবাদীর বিরুদ্ধে বিচার আমলে অস্থায়ী ও অ্যাড ইন্টিরিম ইনজাংশন প্রচারে করিতে আজ্ঞা হয়,
which has been
character, new construction.
We are not talking about the change of the land usage or nature and character of the land. We are only looking at the unauthorized construction, sir. Nothing more.
Nothing more.
Well, the parties are already
Okay, take this order, sir. You are not. This is review.
This is review.
This is review. The scope of review is very limited. The law is a settled law. Mistake apparent on the face of record.
Yes, error apparent on the face of record.
If there is any error on the face of record, we have taken note of the fact that there is a civil suit pending. We are conscious of the fact that there is a suit pending, sir. It is not that this court has passed an order where we were not informed or we were not aware that a civil suit is pending between the parties. We are aware of that fact.
And my lord, the issue of changing.
All right, you take it in appeal, sir, if you are unhappy with our order.
That point has already been decided by the civil court. That was not placed before the court when the matter was taken up for hearing.
Take down.
My lord, may I have kind leave, my lord?
Yes.
Before the division, another justice
क्या
Posak,
लिखा है?
another matter is going on.
Review of the order dated 4/10/2024 passed in MAT number 1919 of 2024. Full stop. This court-wide order dated 4/10/2024, comma, disposed of the writ petition preferred by appeal, disposed of the intra-court appeal preferred by the original appellant by directing the respondent number 3, comma, Pradhan Radha Kantapur Gram Panchayat, comma, Gilarchat, comma, PS Rai Dighi District South 24 Pargana to consider the representation of the appellant after giving an opportunity of hearing to the parties and to take a decision whether the construction is an unauthorized one within a period of 3 months. ये relevant portion यहाँ से उतार लेना para 8, 9, 11 ना page 79 8, 9, 11. The review petitioner in the present petition states that he is the lawful tenant of deceased Chandratan Haldar, qua the plot in question, and had constructed 3 shops of pakka structure with tin and teleshed in the year 1980 and has been running his business for the last 44 years. Full stop. The original appellant, being legal heirs of the deceased landlord, had already initiated civil proceeding against the review petitioner, comma, being title suit number 194/2023, comma, for his eviction from the premises in question. Full stop. In the civil suit, comma, the original appellant, comma, moved an application under Order 39, 1 and 2, CPC seeking interim order challenging that the review petitioner herein is making unauthorized construction in the premises in question, comma, however, comma, the said application was rejected by the civil court wide order dated 12/9/2023. Full stop. It is the submission of the learned counsel for the petitioner that the order dated 4/10/2024 passed by this court directing the Pradhan Gram Panchayat to determine whether there's an unauthorized construction in the premises in question or not was the issue before the civil court, and the same cannot be entertained in the intra-court appeal. Full stop. Hence, he states that since this issue had already been decided and was under consideration and was matter of consideration before the civil court, principle of res judicata is attracted, and this court should not have gone into the same issue. Full stop. It is further submitted by the counsel for the petitioner that the omission to note that the order dated 12/6/2023, by which the civil court had rejected the interim order of the appellant, is an error apparent on the face of record, and hence the review petitioner seeks to review the order dated 4/10/2024. Full stop. This court has heard the argument advanced by the counsel for the, and इसमें ये भी add कर दो, the counsel for the review petitioner has relied on 2 of these judgments. The same are not attracted in the facts and circumstances of the present case. Full stop. This court has heard the argument advanced by the learned counsel for the review petitioner and has examined the documents. Full stop. The law relating to the scope of review petition is no longer res integra. Full stop. It is well settled principle of law that court's jurisdiction of review is not the same as that of an appeal. Full stop. A judgment can be open to review only if there's a mistake or error apparent on the face of the record. Full stop. An error that has to be detected by a process of reasoning cannot be described as an error apparent on the face of record for the court to exercise its power of review. Full stop. By exercising the power of review, comma, the court cannot correct the mistake, but not substitute the view taken by not substitute the view it has taken earlier. Full stop. A judgment may be open to review when any important matter of evidence has emerged after passing of the judgment, comma, subject to the condition that such evidence was not within the knowledge of the party seeking review or could not be produced by it when the order was made, despite undertaking an exercise of due diligence. Full stop. There's a clear distinction between an erroneous decision as against an error apparent on the face of record. Full stop. An erroneous decision can be corrected by the superior court, comma, however, an error apparent on the face of record can only be corrected by exercising review jurisdiction. Full stop. This court, while passing the order dated 4/10/2024, was conscious of the fact that a civil suit is pending between the parties, and while order dated 12/6/2023, the learned trial court had refused to grant any interim relief in favor of the appellant. This fact has been mentioned in para 5 of this court's order dated 4/10/2024, full stop. As stated herein above, comma, by exercising the power of review, comma, court can correct the mistake, but not substitute the view it has taken earlier, full stop. Since that court has passed this audit with order dated 4/10/2024, with the knowledge and existence of the interim order dated 12/6/2023, comma, there is no mistake or error apparent on the face of record. In view thereof, no ground is made out for this court to review its order dated 4/10/2024. The review application is dismissed.
Connected application and it's connected.
And it's connected application. There's nothing there.
My lord,
Oh, one more.
my lord,
One more.
Yes.
Call out the other.
Oh. তাহলে ওটার সঙ্গে
Who's there in the other matter?
Circuit bench matter, item number 1.
My lord, I beg to appear for the respondent, but the review petitioner is represented by Ms. Nag. I don't know.
Yes, Mr.
My
Satadaru.
lord, I'm for the respondent, my lord. The
Yes, I know,
petitioner is
I know
represented
you
by
are
Ms.
appeared.
Nag. There is a.
Where is Miss Nag?
My lord.
Sanjali Nag.
On behalf of the Miss Nag, my lord, senior advocate.
Yes, where is Miss Nag?
Due to some issues, my lord, she is not attend this court today, my lord. Some personal difficulty, and service has not yet been complete, my lord. So because
No, we have received copy, but
The other side is here. Mr. Satadaru is here.
some other
my lord, but
my lord.
He is the answering respondent, sir. There is nobody else is required.
A date may be given, my lord, because I have to.
You know, this is a specially constituted bench. It's very difficult for both the judges to come and sit together. Please take note of this. All right, we'll indicate. Next Monday. Next Monday, 3 o'clock. We'll have it next Monday at 3 o'clock.
my lord.
Please ask Miss Nag to be there, you know.
Definitely, my lord.
My lord.
Yes, my lord. My lord.
Next to next
I'm
Monday.
praying for apology, my lord. I fail
That's
to
all.
understand
My
my
lord.
lord's order, my lord. My lord, it's an assigned matter, only this bench only, my lord.
I have not been given anything like that.
It's an assigned matter only.
Give it, madam. I have not been informed. Maybe you are.
Oh, yeah.
Let the file come. We don't have any idea about it.
My lord, Jela Parishad will take this matter on 9th, my lord, for final hearing, my lord. 2066.
Do you have the file?
Oh. So, yeah, we can pass order for service. You served upon the alleged contemner. What order?
My lord, I don't have the order right now.
What
my lord.
order? Violation of which is complaint of?
My lord, I don't have the order right now, my lord. Kindly give me 5 minutes time, my lord.
Madam, you are mentioning the matter, at least you should have the order.
Come on 21st.
20.
Eh?
My lord, Jela Parishad fixed this matter on 9th, my lord, 9th April.
9th, Jela Police that fixed the matter.
Yes, my lord.
I think it file.
Show what is there.
Just contempt application টা দিতে পারবেন না?
No, just show the applicant contempt.
Contempt application. What is the order?
Others. Oh, no, sorry, partner.
No. এইখানে। Oh, where is the order of the Honorable Division Bench? Who is the specific direction of the Honorable Division Bench?
Lord, kindly fix this matter tomorrow. I don't have the brief right now, my lord.
Take our brief. Is it the order? Violation of which is subject matter?
Nothing is there.
A specific order. Now you read the operative portion of the order and the concluding part. You read. Hey. বাকি সবই না
What is the contempt, madam? The division bench has only confirmed the order of the single judge.
Madam, you have to go to before the single bench. If any specific direction is passed by the Honorable single bench, that order has been affirmed by the Honorable Division Bench.
Division bench has not passed it.
And no specific order. You read, you satisfy yourself.
You read para 15.
আচ্ছা ইয়েটা কোথায় দেখি সিঙ্গেল বেঞ্চ what order single bench pass?
Some property in Chandannagar. There was only a direction to consider the representation and pass a speaking order. If you agree by the speaking order, you carry it forward in appeal. Speaking order. The reason and speaking order, pass a reason order. So hearing page 29, para 29. 23 is directed to communicate the reason order to the writ petitioner as well as the private respondent number tenant.
You want that SDO Chandanagar to initiate a proceedings under section 23 within a fact of the West Bengal Panchayat Act.
Yes, my lord.
So direction was given upon by the learned single bench upon the SDO. That order was challenged before the division bench. Division bench affirmed that order and dismissed the appeal. So you have to go to before the learned single bench. Okay.
And
you can withdraw.
Single judge also didn't really pass any substantive order. He has only passed an order whereby the representation has to be decided after affording an opportunity of hearing to respond number 10 and 11. So whatever order has been passed, you should challenge that order.
SDO did not initiate any proceedings as yet, and hence you have come.
Yes, my lord.
You go to the, you withdraw this and go to the, go before the learned single bench. File a contempt application before the learned single. Okay? So based on your pair, the contempt application is dismissed as withdrawn.
No, my lord.
Then
With liberty to take appropriate step before appropriate forum. So your dismissal order will not prejudice you.
But kindly fix this matter tomorrow, my lord. My lord, kindly, my senior is not here right now, my lord.
So 21. So 21.
Yes, my lord.
Okay, 21. It can be only on
Nothing
Monday
is-
we shall get on
21st.
21st.
The previous,
Circuit bench also
Same. We'll finish both the matters.